Morning.
Morning. How are you doing?
Good, good. How are you?
I guess I need to label mine judge or juror or whatever I'm supposed to be.
Good afternoon. I just want to make sure that you all can hear and see me. Or good morning.
Morning. I can hear you just fine.
Awesome. Sounds good. Thank you so much.
Same here.
Yep, we can hear you.
Awesome. Thank you.
Y'all, I'm going to have to re-enter. I've got an audio issue. I think I can hear everybody.
Hey, Aaron, what's up, man?
Hey, Trey. I got you loud and clear.
Cool.
All right. I'll mute.
Just wanted to confirm that the microphone is working. Thank you.
We can hear you.
Good morning, everyone.
Morning.
Morning, Judge.
How are y'all?
Good.
Good. We are getting close. It looks like we have just about everyone here with us. And we're going to start right on time, just how we like it. Okay. Is everyone ready?
Yes, Your Honor. Would you like our formal introductions for the record?
Sure. I'm going to call the case first, and then you each can give your formal introductions. Okay. The court is now calling case number TGCV 00121 Jordan Gilmore versus Chimes Department Stores Incorporated. Will counsel give introductions, please?
Good morning, Your Honor. Jenna Forster. I'm joined today with my co-counsel, Cheyenne Smith. Together, we represent the plaintiff, Mr. Jordan Gilmore.
Good morning, Your Honor. My name is Tyler Jeffries, last name spelled Jefffies, and I, as well as my co-counsel Marina DeRosa, represent the defense on behalf of Reese Geller in this matter. Your Honor, we have a couple of housekeeping matters. May we proceed?
Yes.
May we assume that all witnesses have been sworn before testifying today?
Yes.
The exhibits have been marked, pre-marked numerically. May those exhibits retain their original markings?
Yes.
If the court would like to hear arguments on objections, would you like us to preface that argument with assuming we're outside the presence of the jury?
Yes.
And would the court like us to proffer experts before receiving their expert opinions pursuant to Rule 702? For Your Honor's awareness, the experts in this case are deposition witnesses and will, the qualifications would have to be read from their deposition.
That's fine.
Sorry, Your Honor, just for clarification, does that mean you would like us to proffer prior to receiving opinions?
Yes.
Yes, thank you, Your Honor. When laying foundation for exhibits, may we share those to the screen, or would you like us to invite the court's attention to the record?
Please share them on the screen.
After exhibits have been admitted, may we share those exhibits to the screen, or would you like us to ask permission before sharing them?
If you'd ask permission first, that would be great.
Yes, Your Honor. And when impeaching or refreshing recollection, may we post the witness's deposition to the screen for the ease of the witness and the court?
Yes.
And finally, may we have the correct pronunciation, excuse me, of Your Honor's last name?
It's Sabo, but anything in that area is permitted.
Perfect. And thank you, Your Honor. With that, we're ready to move to motions.
Perfect. Plaintiffs?
Yes, Your Honor, just one housekeeping matter from the plaintiffs, and that is that before today's trial, we agreed with opposing counsel that some deposition transcripts from some expert witnesses, those expert witnesses would be stipulated to be unavailable in today's case. We would ask to be able to offer some of that testimony into evidence. We asked to be able to use our co-counsel in order to reenact that jury testimony, or reenact that deposition testimony for the jury, if that's all right with Your Honor.
Yes.
With that, the plaintiff has no more housekeeping matters. We do have a couple of substantive matters that we're happy to take up at this time.
Pretrial matters?
Yeah, that's right, Your Honor.
Yes.
Substantive pretrial matters.
Okay. Go ahead.
Sure. The first one is that opposing counsel and I have stipulated to the admissibility of several documents in this case. I'm happy to read all of the numbers of those exhibits for you. We'd like to offer them into evidence at this time.
Okay. And which are those?
Those are, it's a long list, Your Honor,
Yes.
but here's the list. It's exhibits 1 through 7,
Okay.
11, and 16 through 36.
Okay.
And that is my understanding as well, Your Honor.
Perfect. Anything else?
With Your Honor's permission, we'd like to share some of those exhibits during opening statements.
That's fine.
And then lastly, from the plaintiff, we would ask Your Honor to take judicial notice of a few relevant portions of legal codes and regulations in this case. I'm happy to share those with you now.
Please do.
Ms. Smith, if you have that slide available. So these are two of the regulations, one from the Code of Federal Regulations, one from the International Building Code. Your Honor, let me know when you're ready. We have one more slide with one last regulation.
Go ahead. Okay.
That's it from the plaintiff. We're ready to proceed to openings.
Anything from the defense?
Yes, Your Honor, just a couple of substantive matters. Your Honor, we move to exclude any mention of Chimes Department Store and Reese Geller installing a light switch in the building after this 2019 incident occurred, as it is a subsequent remedial measure and is prohibited by Federal Rule of Evidence 407.
Any response, plaintiff?
Yes, Your Honor. We expect that the defendant today will contest control and feasibility, meaning their control over the area where the accident occurred and whether or not it was feasible to make take certain steps to make that area safer for their employees. Under Rule 407, this evidence isn't admissible to prove negligence, as Ms. Jeffries said, but it is admissible for other purposes such as control and feasibility, and we intend to offer it for those purposes.
Defense, is that true?
Your Honor, if I may, the area that the light is in is, it wouldn't be where the light switch would be installed in. And so the alterations or the control is actually inside of the premises, which we are not contesting today. A control can be proved through the lease and other means. It does not need to be proven through the remedial measures that this department store took in order to make that light usable again.
And as to contesting feasibility?
As to contesting feasibility, Your Honor, we don't intend on contesting that it was feasible. We just do contend that it was under their lease that they were prohibited from altering that exact light. Now, as to the switch, I can't speak for my witness, Your Honor, as to what he would say. However, I can, on a good faith basis, believe that if asked about the actual switch, that's actually inside of the store, and that is not the area that's being contested today.
Your Honor, can I respond on that just briefly?
Sure.
As to the control issue, the light that we're talking about actually shines on the back landing. It is our understanding that the defendant intends to contest control over the back landing. That's why we need to be able to show that they did have control over improving the safety in that back landing. It goes directly to control.
Your
Okay.
Honor, may I be heard briefly?
Yes, one last time.
Your Honor, the public policy of this rule is to protect companies and defendants in cases like these from or to not punish them for making things safer after an accident happens. By bringing this in, it's violating public policy in punishing this department store for installing a light switch. And so even going, we are not contesting feasibility, but it does not go to control by any means, and it would go against public policy.
I'm going to go ahead and deny the motion. If we're really not contesting control, I don't think this will really be an issue that is going to make a difference later. So we'll see how it plays out as we proceed today.
Your Honor, we have another motion, if I may.
Yes, go ahead.
Your Honor, as you know,
I'm so sorry to interrupt, Your Honor. I just want to clarify your ruling on that motion. So that was that the plaintiff can offer testimony about that light switch unless anything changes before we get to that point. Is that right?
Yes.
Thank you very much.
All right, go ahead, Ms. Jeffries.
Thank you, Your Honor. As you know, this is a bifurcated trial, and we understand that the plaintiff must prove that there was an injury, but they can say that Mr. Gilmore fell, but anything about the nature and the extent of the injuries that he incurred is improper. This includes that it was a knee injury, that he needed surgery, that he was unable to work, and any pictures of that injury, as that would all go to damages and not liability.
Any argument?
Yes, Your Honor. We agree that this is a bifurcated trial and that damages are not at issue today. But we would like to offer just a little bit of information about the plaintiff's injury. We don't intend to spend a lot of time on it. And if Your Honor wants to know exactly what we intend to offer, I'm happy to tell you that. The reason we want to do that is because, as Ms. Jeffries has pointed out, we do have to prove there was an injury, but we also have to prove that the conditions at this workplace created an unreasonable risk of harm. And the fact that Mr. Gilmore's injuries were so great from falling off of this landing at his workplace goes to show that those conditions were unreasonable. It's circumstantial evidence for the jury to consider as to that point. And that's why we intend to offer, as I said, just a little bit of information about the extent of his injuries.
Maybe
Can you
we heard,
respond?
Your Honor.
Yes.
Yes, Your Honor. The idea that going into the extent of the injury is to allow for the jury to understand that this is a dangerous condition can be proved through other means that are not as prejudicial as these photos and as the photos of the injury, as well as the testimony about the injury and the consequences thereof. They can prove that this was unreasonably dangerous through testimony or through expert witnesses or through regulations. They do not need to go into the extent of the injuries in order to do so. Further, Your Honor, the extent of the injury and the photos of the injury, exhibits 8 and 9, are substantially more prejudicial than they are probative to this case, and again would go only to damages and not to liability.
I'm going to go ahead and grant this motion.
With that, Your Honor, and understanding your ruling, may we exclude exhibits 8 and 9 from being entered into evidence?
Yes.
Those are the photos of the injury. Thank you, Your
Yeah.
Honor. And with that, we are ready to proceed to opening statements.
Your Honor, I just want to be clear about the scope of that ruling so I make sure that I follow it completely. Are we allowed to describe the injury that Mr. Gilmore suffered, that his knee was shattered and that he had to have a knee replacement? Are we allowed to say that?
I think that's fair to say.
Understood.
Perfect. Well, counsel, when you are ready, we are set to begin opening statements.
I'm going to take just one moment to adjust my camera.
And Your Honor, if it is all right with you, I will turn off my camera so that way I'm not clouding the Zoom screen during opposing counsel's opening.
That's fine.
Mr. Gilmore, I'll have you come on in just a minute. Thank you very much. May I proceed?
Yes, ma'am.
Simple steps. The defendant could have taken simple steps to keep its employees safe, but it didn't. Today, you're going to hear about a corporation, Chimes Department Stores. You're going to hear about a store that they own that's located right here in town, here in Waco. You may have been to that store. You may have parked in the parking lot, browsed up and down the aisles, checked out at the register. But where you probably haven't been, what you probably haven't seen, is the area behind that store. It's an area that looks like this. And this. and this. Peeling paint, crumbling concrete, a missing railing, a door that extends into the walkway, and a light nobody knows how to turn on. You will hear that the defendant required its employees to go out onto that back landing in order to take out the trash. They required their employees, if they wanted to take a smoke break, to do it on that back landing. You will hear the defendant could have taken simple steps to make that area safe, but they didn't. I want you to meet someone. Mr. Gilmore, if you could turn on your camera. This is Jordan Gilmore. He's the plaintiff in today's case. He's my client. He'll tell you that he was working for the defendant for Chimes Department Stores. He'll tell you that on January 23rd, 2019, he was out in that back area on those steps you just saw. He was trying to walk up them to go back inside when he fell. He landed on his right side. He shattered his knee. Thank you, Mr. Gilmore. Now, where this story really starts is all the way back in 2005. That's when Chimes Department Stores is looking for a new location, somewhere bigger, somewhere to expand to. And where they land is right in town on Bosque Avenue. Now, when they first signed that lease, when they first set up shop, that back area looks very different from the photos you just saw. It actually looks a little more like this. There is a railing around that landing and along those steps. But you'll hear that just a couple of weeks after the defendant moved in there, they decided that railing had to go. They wrote a request to their landlord to have it removed. And once it was removed, they started to use that area as a loading dock. They back up trucks, offload inventory to move into the store. But what you're going to hear is that even after they started using that area as a loading dock, they didn't stop using it as a place for employees to take breaks. They didn't stop using it as the only way for employees to take out the trash. You're going to hear that area could be dangerous. That at night, when it got dark, there was supposed to be a light, but no one knew how to turn it on. No one had ever seen it on. You're going to hear that Mr. Gilmore wasn't even the first person to get hurt on those steps. You'll hear that in 2010, someone else, another employee, was walking down those steps, carrying a bag of trash. He slipped on that loose concrete. He sprained his wrist. You'll hear the defendant knew about that. That in the defendant's own words, they needed to add adequate lighting. You'll see that they didn't. A simple step they failed to take. Fast forward to January 23rd, 2019. Jordan Gilmore's been working at Chimes for 10 years as a cashier. Around 7 p.m. that night, he and one of his coworkers go out onto that back landing to take a break, smoke a cigarette. Mr. Gilmore, he's someone who tries hard to follow his employer's rules. That's why he's out there in the first place. It's the only place his employer told him he's allowed to smoke. And that's why he doesn't just stay on the landing. He walks down those steps because he's afraid if the smoke from his cigarette blows back into the building, he might get in trouble. Now he finishes his cigarette. He throws the butt in the dumpster. He goes to walk back up those stairs. It's dark. It's windy. He's using the wall for support. But up at the top of the stairs, his coworker is bracing that door open against the wind, and it's right in his path. And between the edge of that door and the edge of that crumbling concrete is just 12 inches of space for him to navigate in the dark. He does his best. He takes a step, but he falls. He feels his body falling. He tries to jump to make a clean landing. It doesn't work. He lands on his right side and he shatters his knee so bad, he has to get a total knee replacement. That is why we're here today. That is why the plaintiff, Mr. Gilmore, is bringing a claim of negligence against the defendant for all those simple steps they could have taken to prevent this from ever happening. Now, because it's the plaintiff who's bringing this claim, it's the plaintiff who's got the burden. That means we have to show to you, and we will show to you, 3 things. 1, that the conditions on that back landing created an unreasonable risk of harm. 2, that the defendant knew or should have known about that risk. And 3, that they didn't use ordinary care to protect their employees just like Mr. Gilmore. Today, in this case, you're going to hear from Jordan Gilmore himself. He will take the stand and tell you exactly what happened to him. He'll tell you that after his coworker helped him up off that concrete, helped him up those stairs, the first thing he did was go to his manager. Tell her what happened. Her response? Yeah, you probably should have fixed those stairs a long time ago. The evidence will show the defendant knew about all those simple steps they should have taken, but they just didn't. Folks, you're not just going to hear that the condition of those stairs was dangerous. You're going to hear it was illegal. You are going to hear testimony from an expert, a professional engineer. That engineer is going to tell you about the building codes that applied to that staircase, to that landing. That engineer will tell you that the law requires a railing. It requires adequate lighting. The defendant did neither. By the end of this case, you will have heard from a lot of witnesses, and you will have seen a lot of evidence. But it'll be clear that this case is really not that complicated. It is as simple as every single one of those simple steps the defendant could have taken to protect their employees. And at the end of this trial, I will come before you again. I will remind you that they didn't take a single one of those steps. I will ask you to find them liable. Thank you.
May I proceed, Your Honor?
You may.
May it please the court. Your Honor, Ms. Forrester, good morning, members of the jury. Now, Ms. Forrester just told you that Chimes is responsible for what happened to Mr. Gilmore, that they could have taken simple steps to ensure Mr. Gilmore's safety. But what the evidence will show you is that Chimes didn't cause this accident. It happened because of the actions of 2 parties. Now, the first party was Kermit Realty. They owned the building where Chimes is located and were legally responsible for building, maintaining, and providing lighting to the exterior of the building and that loading dock. And because of that, Judge Sabo will tell you that you can assess liability against them for anything that they did or didn't do in relation to the building, maintaining or providing any lighting to those areas. Now, Judge Sabo will also tell you that you can assess liability against the plaintiff for what he did or didn't do that resulted in this accident. And the evidence will show that this accident wouldn't have happened but for what the plaintiff did or didn't do that day. Now, today, members of the jury, you're going to have to decide who was ultimately responsible for what happened. Whether it was Mr. Gilmore's own conduct, the landlord's failures, or the plaintiff claims Chimes. And when you consider their claims, remember that the plaintiff has the burden of proof in this case. They have to prove to you by a preponderance of the evidence. They will fail to do so because Chimes acted reasonably and responsibly, while the actions of the landlord and the plaintiff caused this accident. Now, before I talk about that in any more detail, I want to tell you about Chimes and the store that serves this community right here in Waco, as well as the owner, Reese Geller. And I'd like to introduce you to Mr. Geller. Mr. Geller, would you turn your camera on, please? This is Mr. Geller, a family man who was born and raised right here in Waco, Texas. He went to Baylor to get his business degree so that way afterwards he could take over his family business. His grandparents started Chimes department store, and his parents took over, and when they retired, Mr. Geller took over the store. Thank you, Mr. Geller. Now, back in 2005, Chimes department store needed a new location. And so they found a spot in a strip mall, and they signed a lease with Kermit Realty. And today you'll see that lease. And you'll see that before moving in, Chimes and Kermit Realty entered into an agreement of what areas Chimes department store would control and wouldn't control. That the landlord would control common areas and the exterior of the building. That the landlord was responsible for building the loading dock. That the landlord and the landlord alone was responsible for removing the guardrails. And you're going to learn today why the landlord removed the guardrails. Now, Ms. Forrester showed you a bunch of different photos of the Chimes department store loading dock. But what she didn't show you was that it also looks like this. A loading dock being used by delivery people. A loading dock that requires access from the ground up into the store. Now, it looks like this because you can't have a guardrail on a loading dock. Those are not my words. You will hear from a safety engineer who will tell you that you can't have guardrails on a loading dock. And in fact, you will also hear that from the plaintiff himself. He will tell you the very same thing. He will admit to the fact that you can't have guardrails on a loading dock. But that's not all that the plaintiff will have to admit to you. He's also going to have to admit to what he did and didn't do on January 23rd, 2019 that resulted in this accident. You see, the evidence will show that on January 23rd, 2019, that wasn't the first time the plaintiff walked out those doors and headed down those stairs. He had done that for thousands of times over the past 10 years, but had never slipped, never tripped, never fell, and never even had any sort of problem. But this time, he did things differently. This time, he made choices and took risks that resulted in this accident. Ms. Forrester told you that the plaintiff's path was blocked by this door that was being braced by a coworker. But what she didn't tell you was that that is also a choice. That there were, in fact, two doors that the plaintiff could have used. And the plaintiff chose to use that door that is closest to the stairs. But make no mistake, he didn't choose to have that door be fully wide open and his path be clear. Instead, that door was open only about 45 degrees, blocking his path. And instead of choosing to ask a friend or the coworker to open the door fully or to close the door and go in through the other one that has a clear path. He took the risk and tried to go up and around and slipped. Members of the jury, safety is a two-way street. And on January 23rd, 2019, the plaintiff didn't act responsibly. He didn't act responsibly, and he failed to pay attention. And that, together with the actions of the landlord, is the actual reason for this accident. And that's why, at the end of this case, I will ask that you remember those facts and you follow the law by finding Chimes Department Store not liable. Thank you.
If you'll give me just a moment, I'm making sure we're keeping time on track. Okay. Plaintiffs, you can call your first witness when you're ready.
Plaintiff calls Jordan Gilmore. May I proceed?
You may.
Good morning. Could you please introduce yourself?
Good morning. My name is Jordan Gilmore.
Mr. Gilmore, where do you live?
I live in Waco, Texas.
Do you work?
Not anymore.
Where was your last job?
At Chimes Department Stores.
What is Chimes Department Stores?
Well, it sells a little bit of everything. It's similar to Dillard's or stores like that, but I would call it a little more affordable than those types of stores.
What did you do when you worked there?
I was a cashier and I handled customers. I worked in the front of the store.
How long did you do that?
10 years.
Mr. Gilmore, when did you stop working at Chimes?
I stopped working after I got hurt while at work.
Do you remember what day it was that you got hurt?
Yes, I do. January 23rd, 2019.
Roughly where on the premises did you get hurt?
In the back.
I want to talk about that area in the back behind the building. Your Honor, permission to publish to the jury Exhibit 2, which has already been entered.
Yes.
Mr. Gilmore, is this that back area where you got hurt?
Yes, ma'am. That's the landing.
Where do those doors lead to?
They lead back into the store.
On the upper left-hand corner, what is that circled in red?
That is a light.
I'm going to come back to that light later. But first, Your Honor, permission to publish to the jury Exhibit 17, which has already been entered.
You may.
Mr. Gilmore, are those the same steps as we just saw in Exhibit 2?
Yes, ma'am, they are.
When did you usually use these stairs?
So typically I would use these stairs when I went to take out the trash or smoke breaks. But those are really the only times.
How often per week would you estimate you went out onto these stairs?
20 times a week.
Thank you, Ms. Smith. I want to talk about the lighting in this back area. Did you ever have to go out there when it was dark?
Yes, ma'am.
Now, earlier you mentioned that light that was circled in red. If you went out there in the dark, could you use that light?
No.
Why not?
I mean, I'm not really sure. I've actually never even seen it on. And, you know, yeah, it's never been on.
Do you know if there's even a light switch for that light inside the store?
There is, but in the next store, the Tractor Supply store.
So is there a light switch for that light inside the Chimes store?
No, ma'am.
Did you ever talk to anyone in the defendant's management about that?
I did. I talked to one of the managers, Lane Kim.
When you talked to Lane Kim about the fact that you couldn't turn that light on, what did she say?
Well, there's nothing really we can do about it.
Well, if there was nothing they could do about it, let me ask you, did they ever put a lamp outside for you to use?
No,
Did they ever provide a flashlight for you to use?
no,
Did they ever post a warning sign about it being dark in that area?
no.
Let's talk about another part of that back area, the steps. Mr. Gilmore, was there a rail on those steps at any point that you worked there?
No.
Can you describe the condition of those steps?
Decaying. It's in rough shape.
Did the defendant ever post a warning sign about the rough shape those steps were in?
No.
Now that we've talked about what that back area looked like, I want to talk about the day that you got hurt, January 23rd. Do you remember what time it was?
It was roughly 7 o'clock in the evening.
7 p.m. in January. Was it dark outside?
Yes, ma'am.
Was that outside light on?
No, ma'am, it was not.
Did you go out to that back area alone?
No, a colleague of mine, Riley Huntsberger, was with me.
So when you and your colleague went out into that back area, where did Riley Huntsberger stand?
So she was actually standing in the doorway that led out to the back landing.
Did you stay on that landing as well?
No, ma'am, I took the steps down.
Why?
Well, when I take my smoke breaks, I don't want any smoke to get into the store, so I go a little further.
Why don't you want any smoke to get into the store?
We were told not to smoke near the store, and I just didn't want to get any smell into the store.
At some point that night, did you finish your cigarette?
I did.
What did you do at that point?
Well, it was time to go back to work, so I tried to go back into the store.
What happened when you tried to go back into the store?
I was stepping up the steps and lost my footing, and in order to try to save myself, I jumped and I fell and hurt my knee.
I want to make sure the jury understands how this happened.
Okay.
Your Honor, permission to publish Exhibit 3, which is also already in evidence.
You may.
Mr. Gilmore, can you tell us where this photo is taken from?
Yes, so this is at the top of the landing, looking at the bottom of the steps and the door that was blocking the path.
You've already told us that Riley Huntsberger was standing in front of the door, but can you tell us, just describe where that is using this photo?
To the right of this, so on the to the right of the door.
Understood. I'm going to mark RH, and I'm going to draw an arrow pointing to the right edge of this photo. Does that accurately reflect your testimony?
It does.
Where were you standing when you were smoking your cigarette?
Near those cardboard boxes.
I'm going to mark an X near those cardboard boxes. Does that accurately reflect your testimony?
Yes.
You told us that you tried to go up those stairs. Is this the position that door was in when you did that?
Yes, it was.
Do you know why?
Riley was holding it open. It was windy, and I guess she didn't want the door to slam one way or the other.
Why didn't you only use the other door?
I'm not sure.
Let me ask you, this door, was this a source of light into this area?
Yes.
How so?
I mean, so the lights were on in the store, but there wasn't very much light that could escape, and especially when Riley was blocking some of it.
You told us that you tried to come up these stairs. Mr. Gilmore, can you tell me about how far is this distance that I'm marking with a red line from the edge of that door to the edge of that concrete?
That's about 12 inches, I would say.
And as you were trying to go around that door, what happened?
Yeah, I lost my footing and I jumped to try to save myself, and all my weight was on my right leg, and I hurt myself and hurt my knee.
Thank you, Ms. Smith. What did your coworker do after you fell?
Riley came and helped me, made sure I was okay, and helped me get back in the store.
When you got back into the store, did you tell anyone that you'd been hurt?
I talked to the manager about it.
When you talked to the manager about getting hurt on those steps, what did that manager say?
She said, yeah, we probably should have fixed those steps a long time ago. Talked to the owners about it a few times, but we always have bigger things to fix, I guess.
Mr. Gilmore, what were your injuries from that fall?
I had a blowout of the knee, and it required a lot of work to fix.
Did it require a knee replacement?
Yes, ma'am. It was a total knee replacement.
Why did you take your smoke break out behind that store?
It was a rule. The owners required us to do so.
How did the defendant communicate that rule to you?
A letter or a memo, something like that.
I want to show you that memo. Your Honor, permission to share screen with that memo outside the view of the jury until I'm sorry, Your Honor. I believe actually we stipulated to the admissibility of this and that Exhibit 1 is already in evidence. Permission to publish?
You may.
Mr. Gilmore, is this that memo that talked about where to take your smoke breaks?
It is. Actually, I can't read it. It's extremely blurry on my end.
Sure, we're going to make it much easier for you in just a second.
Okay.
We're going to show you an enlarged portion of that first paragraph.
Okay.
Ms. Smith, I'm going to ask you to highlight, starting with if you're going to smoke through the end of this paragraph. Mr. Gilmore, if you could read that for the jury, please.
Yes, ma'am. If you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises.
In this memo where the defendant says that that back area is the only place you can take smoke breaks, does the defendant warn employees that the light in that area doesn't work?
No.
Does the defendant warn employees that there's no railing in that area?
No.
Does the defendant warn employees about the crumbling concrete?
No.
Does the defendant warn employees about that landing at all?
No.
Thank you. Pass the witness.
Cross-examination, Your Honor.
You may.
Good morning still, Mr. Gilmore.
Good morning.
Now, you've been working at Chimes for about 10 years, right?
Yes.
And you smoked that entire time that you worked at Chimes.
Yes.
You smoked about a pack a day, right?
Yes.
And you took at least one smoke break every day, correct?
Yes.
Out on the loading dock?
The back landing, yeah.
So that is the loading dock. That's a yes to my question, correct?
Yes.
You also went out to the loading dock to throw out trash, right?
Yes.
You did that about twice a day,
Twice per shift.
meaning that you went out to the loading dock around 20 times a week, right? That's your estimate.
That is.
And this may be a funny question, but there's 52 weeks in a year.
Last I checked.
Last I checked as well. And so that would equal out to, if my math is correct, about 1,000 times a year
Yes, ma'am.
over the last 10 years.
Yes.
Now, over the years, you would go out to that loading dock during the day.
I would go out during the day. Could you repeat that?
Yes, I can. Over the years, you would go out to the loading dock during the day, correct?
Yes.
And also at night.
Yes.
And prior to January 23rd of 2019, you never fell,
No.
you never tripped,
No.
you never slipped,
No.
you never did any of those things because of any problem with the stairs, right?
I suppose.
You never did any of those things because of problems with the concrete
Yeah. Yes.
or a problem with the lighting, as I am having.
Yes.
Well, let's talk about the lighting a bit more in detail, okay?
Okay.
Now, you said that the lights weren't on regularly, right?
I've actually never seen it on.
Well, and you said that you spoke about that to your supervisor,
Yes.
but you can't tell us the name of the supervisor that you spoke to about the lighting issue.
Um, I don't recall.
And you can't tell us the exact date when you talked to the supervisor about the lighting issue.
No, I don't recall.
And you also don't recall even an approximate date, right?
No, that's correct.
But you do know that Chimes didn't control that exterior lighting, right?
The switch was, yeah, it was in Tractor Supply.
That's right. You knew that there was not a switch in the store, correct?
Correct.
But Chimes did have interior lights near that back door.
Yes.
And you could use that light source when you went outside.
It's somewhat, but yes, I would agree.
You could do that by opening the doors out back.
Yeah. Yes.
And you could in fact open both doors, right?
Yes.
You could have used a flashlight.
Yes.
You could have even used your phone, right?
In general or on that instance?
In general, you could have used your phone, correct?
Yes.
And you could have brought your phone out with you on January 23rd, 2019, right?
I could have. Yes.
But you didn't.
No, I didn't.
And you didn't open both doors either.
No.
You only opened one door.
Yes.
But your coworker was blocking the light from that door.
Yes.
You didn't ask your coworker to move.
I didn't.
You didn't ask your coworker to open both doors.
I didn't.
And you didn't stand with your friend right on that landing, right?
No.
No one told you that you couldn't stand there to take a smoke break, correct?
That's correct.
No memos were sent out saying that you can't stand on the landing, right?
That's correct.
No rules prevented you from standing there either, correct?
It's correct.
Instead, you walked out on the landing,
Yes.
you walked down the steps,
Yes.
and you had your cigarette.
Yes.
And then you headed back up those steps.
Yes.
And when you did that, you held onto the wall, correct?
Yes.
And you said you did that for safety purposes.
Safety, stability, yes.
But that's not what you said on the date of the accident, right?
I don't recall.
Well, when you gave a statement to your supervisor after the day of the accident,
I did.
you stated exactly what happened that day.
To the best of my ability, yes, I believe so.
Everything that you did and didn't do.
I believe so.
Nowhere in that statement did you say that you hung onto the wall.
I don't remember the statement exactly.
Well, we're still talking about the statement that you just told me you recalled speaking to your supervisor and making. And nowhere in that statement did you say that you hung onto the wall, correct?
Correct.
Nowhere in that statement did you complain about the lighting.
Yeah, correct.
And nowhere in that statement do you complain that there was no guardrail.
Correct.
Now, you didn't complain, you didn't complain about the guardrail because it wasn't an issue for you, right?
Yes.
Because according to you, a guardrail wasn't needed there.
Yes.
Because in your own words, how could you put a railing on a loading dock?
Yes, I said that.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. Can Mr. Gilmore be excused?
He may. Are there any other witnesses for the plaintiff?
No other live witnesses, but at this time, we'd like to call by deposition Kelly Danes. May I proceed?
You may.
I'm going to start with page 2, lines 6 through 7. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
I apologize, Your Honor. I am sorry to interrupt. I just have a quick question about how you would like to address objections pertaining to the deposition witnesses. Would you prefer that I do it as the deposition is happening or when opposing counsel reads out the sections that she will be reading?
Just go ahead and do it as the deposition is happening.
Thank you, Your Honor.
Go ahead.
Page 2, lines 12 through 14. Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Moving to page 2, line 24 through page 3, line 12. I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well, and I passed.
In which states are you registered as a professional engineer?
I'm currently registered in California, Texas, Wisconsin, Virginia, Louisiana, Idaho, and Washington. And I'm also registered with the National Council of Examiners for Engineering and Surveying.
Moving to page 3, line 15. What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Moving to page 8. At this time, Your Honor, plaintiff offers Kelly Danes as an expert in professional engineering and compliance.
But Your Honor, at this time I would object. We haven't heard any methods or anything that this witness reviewed as to the basis of her opinions or even if these methods and standards are accepted by other experts in her field.
Response, plaintiff?
Yes, Your Honor. She has testified that she is certified in several states and registered with the National Council of Examiners. She's testified as to what she does, that she helps investigate engineering issues and specializes in safety, patents, and regulations. We've certainly laid enough foundation for her to testify to her conclusions today.
I'd agree.
I'm going to move next to page 8. Line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question. And the facilities in question must be in compliance with those codes and regulations.
Moving to page 15, lines 7 through 15. Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed.
Objection, Your Honor. May be heard outside the presence of the jury.
You may.
Your Honor, this portion of the deposition goes into legal conclusions that this witness is not qualified to give. If I may, Your Honor, it does go into the fact that they should have put up a guardrail, and doing that would have prevented this entire accident. This is a conclusion that this witness cannot make.
Response?
Yes, Your Honor. The conclusions that Ms. Danes makes in this answer aren't actually legal conclusions. It's true that she does say the defendant should have done certain things, but she doesn't say that not doing those things constitutes negligence. She just says that in her expertise and her expert opinion, the defendant should have done those things. Now, that is squarely within her expertise as a professional engineer as to what should have been done in the construction of this area. It's not an improper opinion.
Overruled. Continue.
I'm going to ask the question again. Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on those steps. It would have been easy. And if the defendant had taken those simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
Thank you. Pass the witness.
Your Honor, we also have portions of this deposition that we will be reading in. Would you prefer for us to do it at this time?
Please do.
Yes, and may my co-counsel act as the witness, Your Honor.
Yes.
Beginning with page 3, line 22 to 23. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trial are about 99% of what I do at this point.
Moving on to page 4, line 21 to 24, and we will continue on to page 5, lines 1 through 2. Question: how did you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've done work for in the past, so this isn't the first time that I've consulted in one of their cases.
I guess that means that question. Guess that means they liked what you did in those other cases?
What can I say? I'm good at what I do.
And now we will go down, Your Honor, to page 13, lines 16 through 24. And this, the answer does bleed onto page 14, and we will go from page, or on page 14, lines 1 through 21. Question. All right, anything else?
Let's take a look at OSHA 1910.24H and IBC 1012.1. 1910.24H requires railings on all stair platforms, and 1012.1 requires guardrails on all landings that are located more than 30 inches above the ground. In this case, as you can see from the photographs, I measured the distance from the ground to the top of that landing, and it was 34 inches. So this landing would be subject to both standards. Again, like we discussed earlier, this landing had a guardrail at one point and it was removed. And depending on exactly where the plaintiff fell, if the stair handrails didn't provide enough protection, then a guardrail around the landing would have given him something to grab onto to keep from falling.
Do either 1910.24 or 1012.1 apply to loading docks?
They don't mention loading docks specifically, but this wasn't a loading dock.
Why do you say that?
Well, just look at how it was used. Employees use this area to throw trash in the dumpster and used it to take smoke breaks. So this wasn't just a loading dock.
You would agree, though, that this area was used by Chimes as a loading dock at times?
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes's ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Your Honor, this concludes our reading of or deposition testimony of Kelly Danes.
Is there any redirect on this portion, I suppose?
No redirect, Your Honor, and at this time, plaintiff rests his case in chief.
Okay, any matters we need to take up? Does anyone need a brief recess before we let the defense present their case?
Yes, please, Your Honor.
As far as a recess?
Yes, a brief
Yeah.
recess, about 5 minutes would be great.
Okay, we'll take a brief 5-minute recess and start back at 11:08.
Your Honor, is it all right if we get a time check when we come back?
Yes.
Thanks so much.
Uh-huh.
Thank you, Your Honor.
Okay, is council ready?
Yes, Your Honor.
You may proceed.
Defense calls Reese Geller.
I'm sorry, before we begin, you asked for a time check. Plaintiffs, you have 26 minutes and 46 seconds remaining. And defense, you have 34 minutes and 36 seconds remaining.
Thank you, Your Honor.
Okay, now you may proceed.
Thank you, Your Honor. Good morning. Please introduce yourself to the jury.
Reese Geller,
And how old are you, Mr. Geller?
45,
And where do you currently live?
Waco.
Are you from Waco?
Yes.
And do you currently have any family in Waco?
Yes, I have my wife Peyton and my 3 kids.
And did you go to college at all?
Yes, I attended hometown Baylor.
And did you get a degree at Baylor?
Yes, I did. I got my business degree.
And what do you currently do for a living?
I am the owner of Chimes.
How did you get that job?
It's a family business. So my grandparents started it, and then parents ran it, and then I took over from my parents.
Did you start out as the owner of Chimes?
No, I had to work my way up.
Where did you start originally?
I was a buyer for merchandise for the store.
What does a buyer do?
You have a bunch of stuff on the actual floor of the store, but someone's got to go out and figure out what's going to sell and whatnot. So I was in charge of what merchandise we should bring in and that kind of stuff.
I know you mentioned that you're currently the owner. How long have you been the owner?
10 years, I think.
And you mentioned buying merchandise for the store. What kind of store is Chimes?
I would call it a department store. So, like a Kohl's or JC Penney, something like that.
Now, are you a chain like Kohl's and JCPenney's?
No,
How many locations do you have?
just one.
And where is that located?
It's on Bosque Street.
Here in Waco?
Yeah, Bosque Avenue.
And Mr. Geller, why are you here today?
Here today because I'm getting sued.
And do you know who is suing you?
Yes, a former employee.
And do you know why they are suing you?
Yeah, because they fell off some stairs and hurt themselves.
And do you know where that fall happened?
Yes, in the back of the store.
At the back of this, in the back of the store, inside or outside?
Outside, so on the loading dock.
And what is a loading dock?
Yeah, so it was like 4 stairs, and it's this little slab of concrete that we have 2 doors that open up nice and wide. And so we can bring in merchandise from different deliveries, and we have a trash can back there to throw away trash, just kind of, like the unattractive part of the store.
And how often would you say that you use this loading dock?
I think we use it every day.
And was this a loading dock when you first got the building?
Well, I mean, I guess it depends on what you're going to use the store for. It is meant to be something of that sort, but it wasn't necessarily set up for that when we first moved in, because it had a railing and you can't really like back a truck in and like bring a lot of materials in with the railing. So we had to ask Kermit, the owner, to take it out for us to accommodate the type of store we were running.
And do you allow your employees to go onto the loading dock without the railing?
Yes.
And do you expect that they are safe when they are out there?
Yes.
And to your knowledge, are they safe when they're out there?
Yeah. Haven't really had any problems over 10 years. So.
And over the 10 years that you've been, about how many problems have there been?
Well, we have this incident, and then we have one instance where I forget who it was, but someone slipped down the stairs. Happens sometimes with stairs. People just lose their balance or they're not paying attention.
And would that employee be Jordan Stiles?
Yes, sounds right.
And do you know what they were doing when they were going out onto the stairs?
I'm not positive. Maybe taking out the trash. I can't really remember.
It's okay. Did you make any changes after that incident?
No. I mean, it was just an accident of slipping down the stairs. I didn't find it necessary to do anything, and I don't really, I'm not in control of the back part of the store. So, I mean, I personally would have done it, but if I thought something was wrong, I guess I could have reached out to the owner.
No, what do you mean when you say you're not in control of the back area?
Yeah. So, I mean, we lease the store from the landlord, Kermit, and in our lease, we have designated areas that we are responsible for. And so the back of the store, or the loading dock area, that's on Kermit. So that's why we had to reach out about the railing. But then like inside the store and the parking lot's on us. So it's just out of our hands if it's in the back.
Now, does your lease designate what areas you do or don't control?
Yes.
And would you recognize that portions of that lease if I showed it to you today?
Yes.
Your Honor, we have portions of what has already been admitted into evidence of Exhibit 11. May we publish those to the screen?
You may.
And for the court, we invite the court's attention to pages 9 and 10 of Exhibit 11. Mr. Geller, can you see that exhibit?
I can.
And can you see Article 6.1?
Yes, I can.
Mr. Rosa, can we blow that up for Mr. Geller? Thank you so much. What does this Article 6.1 mean to you?
Yeah, so this is just talking about the common areas and how the landlord's in charge of the common areas.
So it's your understanding that you don't control the common areas?
Yeah, I know it's for it's the landlord's control.
Now, was the loading dock a common area?
Yes.
And now I'm directing your attention to page 10, Article 6.3. Can you see that?
I can, yes.
What does that section mean to you?
This is what I was just previously saying, that Kermit, the landlord, is responsible for the common areas. It's not us.
Thank you, Mr. Rosa. Now, in that lease, there is a site map, right?
Yes, I think it's at the very end.
If I showed you a photo, or excuse me, if I showed you a copy of that site map with some indications that you made previously, would you recognize that?
Yes, I would.
Your Honor, we have what has been pre-marked for identification as Exhibit 12. May we post it to the screen constructively outside the presence of the jury? This has not been admitted into evidence yet.
You may.
Thank you. Mr. Geller, do you recognize this?
Yes, I do.
What is it?
This is the site map that we were talking about, and the top, like where that red X is right below, that's our store, and then the middle of the picture is the parking lot.
And do you see that red X at the top of the diagram?
Yes, I do.
Do you know who made that red X?
I did.
I'm sorry, you said you did?
Yes.
Is this a fair and accurate depiction of the site map as it is in your lease, as well as where you made that indication?
Yes.
Thank you, Your Honor. We offer into evidence what has been pre-marked for identification as Exhibit 12 into evidence as Exhibit 12.
Any objections?
None.
It's admitted.
Thank you. Mr. Geller, we see a bunch of cross hatches. What do those mean?
That's the area that that I'm responsible for.
And what does that red X indicate?
That's the loading dock.
And underneath that red X, is there any cross hatches under there?
No, there is not.
And so to the best of your understanding, what does that mean?
That means that that's Curbett's, the landlord, responsibility and not my responsibility. And so anything that goes on back there in terms of the actual properties, it's under his control and it's his responsibility.
And using this site diagram, where did this accident happen?
On the red X.
Thank you, Mr. Rosa. And thank you, Mr. Geller. I have no further questions.
Cross,
Yes, Your Honor, may I proceed?
you may.
Good morning or afternoon, depending on where you are, Mr. Geller. How are you?
Good, how are you?
Good, thank you. You're the owner of Chimes Department Store, aren't you?
Yes,
Been the owner for 10 years.
yes,
Chimes has been in its current location since 2005.
yes,
I want to talk about that location. There's an exit at the back of that store, right?
yes,
You told us you use that exit as a loading dock
yes,
to bring things in and out of the store,
that's correct.
but you use it for other purposes.
In terms of coming in and out of the store,
You use that back area for other purposes, don't you?
other purposes for what? I'm a little confused.
You use that back area for your employees to take out trash to the dumpster, right?
Oh, yes, other than loading, yes, we use it for other purposes.
So you use it for employees to take out trash.
Yes, they take trash in the back.
They're required to do that as part of their job.
Yes,
You also use that back area for employees to take smoke breaks.
yes,
It's the only place they're allowed to take smoke breaks.
yes,
You told us a few minutes ago that you didn't think you had control over that back area. Is that right?
yes,
Let's talk about who did have control. It was Chimes who requested that the railing around that landing be removed.
yes,
It was Chimes who used that landing as a loading dock.
yes,
It was Chimes who used that loading dock every day.
yes,
It was Chimes who added a dumpster back there.
yes,
It was Chimes who instructed their employees to take out the trash there.
yes,
It was Chimes who instructed employees to keep that area clean.
yes,
You told us you thought your landlord was responsible for that area, true?
they are.
You know your landlord doesn't use that area.
I mean, it's a common area, so anyone can use it.
You know your landlord doesn't use it.
As far as I'm aware, yeah.
As far as you're aware, your landlord doesn't clean that area.
No, I mean, we keep it pretty clean, so he doesn't have to, but I guess he could.
Your landlord doesn't clean that area.
No,
Your landlord doesn't inspect that area.
no,
You never saw anyone else clean up that area.
nope,
You never saw anyone else use that area.
nope,
You've never seen anyone else near that area.
anyone else in terms of outside my employees.
You've never seen anyone other than your employees near that area.
Well, the delivery men, they're not my employees, so I've seen them, so I guess I can't say that.
You've never seen anyone in that area for any purpose other than Chimes business. Is that right?
Ooh, yes, that is correct.
So let's talk about your loading dock.
Okay.
Now, when Chimes moved in, it wanted to make some changes.
Yes, it wasn't quite usable the way it was.
Right? You had to remove the railing.
Yes,
I want to be clear. You asked them to remove the entire railing,
yes,
and they did.
they did.
They removed the railing around the landing.
Yes.
That's the flat part, right?
Up top, yes, that's the, I mean, if you're gonna back a truck up, you can't have a railing there.
But they also removed the railing from the stairs.
Yes.
I'd like to look at Exhibit 33 together. Your Honor, this is already in evidence. Permission to publish?
You may.
Mr. Geller, this is a photo of that back landing.
Yes.
It's a photo of that landing being used as a loading dock.
Yes.
And they're using the flat part, the landing itself, to do the loading.
Yes, they are.
In this photo, they're not using the stairs to do the loading.
Well, I mean, they had to get up the stairs to get on to the land. So yeah,
Sure, they had to walk up the stairs, but you don't see them loading any items, any of those boxes on those stairs, do you?
no.
But still, there's no railing on the stairs.
Well, I mean, in this picture, it's not a problem, but it could be a problem if you had a bigger object or you're coming at a different angle. I mean, it just gets in the way for the purpose that it's being used for.
Mr. Geller, there's no railing on the stairs.
No.
Let's take a look at Exhibit 3. Your Honor, permission to publish? This is already in evidence as well.
You may.
Mr. Geller, this is a photo from the top of the stairs.
Yes.
You can see here that there is a hole in the corner of that top step that I'm circling in red.
Yes.
You can see a hole in that bottom step that I'm circling in red.
Yes.
Those holes are where the railing used to be.
That's correct.
You could have asked the landlord to patch up those holes.
Yeah, I could have if they served as an issue that I thought needed to be fixed, I guess.
You could have.
Me personally, I couldn't fix those. No, I had to ask the landlord.
You could have asked them. Yes or no?
Oh, yeah, I could have asked.
You didn't.
Yeah, I mean, I could have asked him to do a lot of things, but if it's not necessary, then why would I do it?
That's right. You could have asked them to take a lot of steps, couldn't you?
Yeah, but I mean, for what the building was being used for, I mean, this part Waco, it's not like we're living in a high-end area and everyone's made of money. I'm not gonna nitpick things that aren't an issue.
Well, let's talk about some more things you could have asked them to do. And thank you, Ms. Smith. I want to talk about the lighting. There was an outdoor light, right?
Yes.
But you knew the switch for that light. Well, it wasn't inside your store.
Yeah, no, we didn't have a switch in our store.
It was next door.
It was next door.
Before January 23rd, you never installed a light switch in your store.
No.
But after Mr. Gilmore's accident, you did.
Yes, I did.
Well, if that light switch wasn't in place on January 23rd, you could have put a lamp outside on the landing, right?
I don't know that a lamp would have really fit out there, but sure.
You could have put a lamp on the ground next to the landing.
I mean, feasibly, it just wouldn't really work, but yes, I could have put a lamp there. But then you're talking about people knocking it over and stuff, it gets in the way. So I wouldn't say that that's a very feasible option.
But you could have.
I could have.
You could have left a flashlight by the door for your employees to use.
I mean, flashlights are pretty outdated. Everyone's got their phones, so I feel like that, no.
Mr. Geller, I'm going to direct you back to my question. You could have left a flashlight, yes or no?
I could have, yes.
You didn't.
No.
You could have posted a warning sign telling people it would be dark, couldn't you?
I mean, yeah, I could have posted a warning sign, but did the employees need a warning sign?
You didn't post a warning sign, did you?
No, I didn't.
Mr. Gilmore wasn't even the first of your employees to get hurt on those steps, was he?
In terms of going out in the back, no, we had a lady slip, a former employee slipped down the stairs.
Is it your testimony that employee was a lady?
No, it wasn't a lady, sorry, it was a man.
That employee was Jason Stiles. Do you remember his name?
Yes, Jason Stiles.
I'd like to show you Exhibit 14. Your Honor, I'd like to do this constructively outside the view of the jury since this isn't in evidence yet.
Go ahead.
Mr. Geller, this might be hard for you to see, but this is on page 164 in your materials. This is an incident report from when Mr. Stiles got hurt, right?
It looks like it.
It was prepared by your company.
Yes, I think so. Is that 2003? So I think that's before I was the owner.
2010.
Oh, that's date hired. Sorry, it's hard to read. Okay, yes, I see what you're saying. Yes,
This is a fair and accurate copy of that report.
yes.
Plaintiff offers Exhibit 14.
Any objections?
Yes, Your Honor, this isn't the full exhibit. This is only one page. This is a 3-page document. So if this is going to be entered, I just want to make sure that this witness can recognize each and every page of that document. Further, Your Honor, this is hearsay without exception. At this point, there's multiple levels of hearsay within this document.
Response?
Yes, Your Honor, I'll take those one at a time. First, I directed Mr. Geller to the page in his materials where he can look at them. If he has a problem with any one of those 3 pages, he can feel free to say so. Secondly, to the hearsay issue, there is hearsay within hearsay in this document. I'm happy to address both levels. On the first level, the face of the document itself, this is a document that was prepared by the defendant. It is a party opponent statement under 801D1. There are statements within this document that are made by both April Nardini, the manager who prepared this statement, as well as Jason Stiles, who was a person within the defendant's employ at the time that those statements were made. All of these statements are statements by the party opponent or an agent thereof and are covered under 801D2A or 801D2D. Secondly, Your Honor, if not for the truth, they go to show notice that the defendant was aware of this situation.
Any response?
Yes, Your Honor. This is not an opposing party's statement for them being an agent. This isn't made by any individual in a representative capacity. Further, Your Honor, this employee no longer works at, or excuse me, Your Honor, we don't know the employment status of either witness or of either person at this time. And also there is within the, excuse me, Your Honor, within the document itself, it does state that there is a recording. And under the best evidence rule, that recording would need to be accounted for in order for the document itself to come in. And that recording has not been accounted for.
I'm going to go ahead and overrule the objection. The statement, what was it, Exhibit 14?
That's right, Your Honor.
Is admitted.
Ms. Smith, if we could look at the first page of that document, and if you could enlarge the last paragraph. If you could start highlighting from "as I was walking down the steps," that sentence and the next sentence. Mr. Geller, I'm going to read this aloud. Please follow along. "As I was walking down the steps, I slipped on what I think was loose concrete, and I fell face first onto the ground at the bottom of the steps." Mr. Geller, after this accident, you didn't make any effort to clean up loose concrete, did you?
No,
I'm going to keep reading. "There was nothing for me to grab onto, so I couldn't stop my fall." Mr. Geller, after this accident, you didn't make any effort to put in a guardrail or anything for employees to grab onto.
no,
Ms. Smith, if we could go to the next page. If we could highlight that bottom section. Mr. Geller, at the top here, it says "for chimes use only," right?
yes,
Says it's to be filled out by the supervisor or manager.
yes,
I'm going to highlight, or Ms. Smith is going to highlight, and I'm going to read the last question and answer. Please follow along. "Are there any steps that should be taken by chimes to help prevent such injuries in the future? Make sure there is adequate lighting on the loading dock." Mr. Geller, after this accident, you didn't make any effort to make sure there was adequate lighting on the loading dock.
I did not.
Thank you. Nothing further.
Any redirect?
Just briefly, Your Honor. Mr. Geller, you were asked extensively about the loading dock and the guardrail. Why did you remove the guardrail? Or why did you have the guardrail removed? Excuse me.
Like I was saying earlier, it wasn't, it was just in the way for what we needed the back of the store for. And so we took it out in order to accommodate that.
And you and your employees, or excuse me, how do you and your employees classify that back area? What do you call that back area?
The loading dock or the landing area.
Thank you, Your Honor. No, nothing further. May the witness be excused.
You may.
Your Honor, the next witness that we have is a deposition witness, Perry Hayden. And my co-counsel will be acting as Ms. Hayden.
Okay.
And we will be beginning on page 2, line 5 through 6. Question. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
And moving to lines 9 through 23 on that same page. Question. Where do you live?
I live in Austin, Texas.
What do you do for a living?
I'm a compliance safety and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that is responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try and make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We're all about employee safety.
And what do you do at OSHA as a compliance, safety, and health officer? We'll now move on to page 3, lines 1 through 10, beginning with Ms. Hayden's answer.
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
And what happens if a workplace doesn't comply with those OSHA standards?
Well, there are lots of potential implications, but at the very least, it would result in a citation for any violations that we find. Then the employer would have a chance to correct the issue that we find. Then, if they fail to take corrective steps, we might issue fines.
Moving on to line 16 through 24 on that same page, and we'll be continuing on to page 4, lines 1 through 4. Question. How long have you worked for OSHA?
Since I got out of school, so at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands? I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
What kind of education did you receive before becoming an inspector for OSHA?
I graduated from high school and then I went to Texas State Technical College, where I got an associate's degree in occupational safety compliance technology. Then I went on and got a second associate's degree in environmental technology compliance.
Moving on to page 5, lines 1 through 8. Question, are you being paid by anyone for your time here today?
Nope.
Have you ever been retained by anyone to serve as an expert in this case?
Nope.
All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018, so I assume that's why I'm here.
Moving on to line 23. And at this time, Your Honor, we would like to publish to the jury Exhibit 36, which has already been admitted into evidence.
You may.
And we will be continuing on to the entire page of page 6, lines 1 through 23. Question, During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
And how do you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous and that would necessitate a citation.
Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Why did you inspect that area?
At the beginning of every inspection, I asked the representative for the employer to outline for me all the areas where their employees work. When I asked that question to the manager at Chimes that day, they told me that the employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
When you went out there, what did you notice about the steps in the landing area? We are now moving to page 7, lines 1 through 19, beginning with Ms. Hayden's answer.
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of some of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
If there was such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed, so I asked the manager that was walking around with me during the inspection about the fact that there was no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
And why does that matter?
Because loading docks don't have to have guardrails,
How do you know that?
because OSHA says so.
Now we are moving to page 8, lines 20 through 24, continuing on to page 9, lines 1 through 22. Question: is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28 B1 III clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Have you had a chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area in the back of the store?
Well, I'm sure Ms. Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of the stairwell. This was a loading dock. And the provisions cited by Kelly Danes don't deal with loading docks.
Was this area behind the store exclusively used as a loading dock?
No, it's my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well, but I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
Thank you, Your Honor. And we pass the witness for any deposition reading they have. And Mr. Rosa, you can take down Exhibit 36.
Anything from plaintiffs?
Yes, Your Honor.
Go ahead.
Thank you. Give me just one moment. Page 11, line 16 through page 12, line 3. Did you ever inspect that area behind the store at night?
No, Only during the daytime.
Did you notice a light out there while you were doing your inspection?
I did. You'll see that noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
Thank you. Nothing further.
Thank you, Your Honor. With that, the defense rests.
Council ready for closings?
Your Honor, do you mind if we take another short recess before we do that?
Yes, we will take another, let's shoot for 3 to 5 minutes. If everyone is back in 3, we'll get started.
Sounds
And Your
great.
Honor, could we get a time check at your earliest convenience? Thank you.
Okay, at this time, plaintiffs, it looks like you have 14 minutes and 27 seconds left. And defense counsel, you have 15 minutes and 52 seconds left.
Thank you, Your Honor.
Okay, plaintiff, are you ready for closing?
I am.
Proceed when ready.
Thank you. Simple steps. The defendant could have taken simple steps to keep their employees safe, but they didn't. Today you heard about the back landing behind the Chimes department store here in Waco. You saw photos of it. You saw the peeling paint, the crumbling concrete, the missing railing. You heard about the light that doesn't turn on. You saw the door that swings out into the walkway. You heard that those conditions, that area, the defendant not just allowed, encouraged, the defendant required its employees to use that area. They were required to use that area to take out the trash. They were required to use that area if they wanted to smoke a cigarette on a break. That back landing was an accident waiting to happen. And on January 23rd, an accident did happen. That day, Jordan Gilmore walked down those steps in the dark, in the wind, to smoke a cigarette. He threw out the butt, went back up those steps, leaned against that wall for support. But his coworker was at the top of the steps, trying to hold open that door as best he could against the wind. Mr. Gilmore tried to go around in that 12 inches of space between the door and the ledge of that crumbling concrete. In the dark, he took a wrong step and he fell. His knee had to be totally replaced. It was shattered. You heard today that that could have been prevented with any number of simple steps the defendant could have taken. Because they didn't, that is why we are here. That is why Mr. Gilmore brought a claim of negligence against Chimes department stores. Now, members of the jury, you are here to do one job, to answer one simple question. Did the defendant's negligence cause Mr. Gilmore's injuries? Now, I want to be clear about this. It is the plaintiff who had the burden. It's a burden we accepted willingly. We had to prove every element of the claim of negligence by a preponderance of the evidence. That means by the greater weight of the credible evidence, but even more simply, it means more likely than not. If you look at the evidence in this case and you think it is even just the tiniest bit more likely than not that the defendant's failure to act caused Mr. Gilmore's injuries, that's it. Case closed. So what are the elements of negligence? What is it that we had to prove? We had to show you, number one, that those conditions created an unreasonable risk of harm. Number two, that the defendant knew or reasonably should have known of the danger. Number three, the defendant failed to use ordinary care to protect its employees like Mr. Gilmore. Now, we had to prove each one of these, so we're going to talk about each one of these. We're going to start with number one, unreasonable risk of harm. Folks, this is not hard. Told you at the beginning of this case it would not be complicated. It is not. You can use your common sense, your own eyes. You saw that crumbling concrete, that lack of a railing. You didn't see photos of the outside at night, but you can imagine what that would look like with only the light coming out of the open doors to show you where you're going. Folks, your common sense alone is enough to tell you this is not reasonable, especially when there were such simple steps they could have taken to make this safer. But you don't have to rely just on your common sense if you don't want to. Because you heard today, these steps weren't just dangerous. They were illegal. when you go back to deliberate, you will have the benefit of these regulations with you. You'll be able to consider them. And you heard Kelly Danes, an expert, a professional engineer, talk about what these regulations mean. She told you the law requires a railing on the open sides of exposed stairways. The law requires stairways to have handrails on each side. There are more requirements. The law requires that the means of egress, meaning how you exit a building, should be illuminated. It should be lit at all times. The building space is occupied, that employees are in that building. Let's talk about what law means. These didn't just come from nowhere. Law is important because laws are something that our best experts sit in a room and decide will make our society safer. And then we all agree, business owners, employees, we agree to follow those laws together to keep each other safe. The defendant just chose not to. They just decided it wasn't worth it to them. How do you know that those conditions were unreasonable? Well, because the law tells you so. You don't have to guess. That's how we proved that first element. So we'll move on to the second. How did we show you that the defendant knew or should have known about the risk? Well, first of all, folks, the defendant's employees, their management, that owner, well, they worked at that store every day. These are not hidden dangers. The very first thing I did this morning in my opening statement was show you those photos. From that moment, you knew what the problem was. Every single day that the defendant's management was at that store, they could have seen what the problem was. They could have fixed it. But it's not just that they reasonably should have known, folks. It's that you had concrete proof that they did know. We had it from the mouths of the managers themselves. Mr. Gilmore gets hurt. His coworker helps him inside. He tells his manager. The manager says, "Oh yeah, we should have fixed that years ago." I keep telling the owners. They're saying we got bigger problems to fix first. Not just that, think about that OSHA inspector that the defendant brought before you by way of deposition. Think about that portion of that report I read, where that inspector says, well, I asked about the light out there. We all know the light's required. I asked about the light out there, and the manager told me it turns on automatically. It's on all the time. Folks, not a single person in this courtroom today could tell you that was true. What does that mean? It means the defendant's employee lied to a public official. And what does that mean? That's an admission of guilt. It shows they knew what the problems were. They didn't fix them. That's how we showed you they knew or should have known. So we can move on to that third element. Did the defendant fail to use ordinary care to protect its employees? I want you to think back to when I cross-examined the owner of that store, Reese Geller. I want you to think about his attitude, his demeanor as he sat there. I asked him, you could have posted a sign. You could have left a flashlight out there. Folks, he almost laughed at me. Simple, easy steps. He just didn't think were important. He told you, well, we're not made of money here in Waco. I'm not going to spend money on things we don't need. Folks, how much does it cost to leave a flashlight by the door? To print out one piece of paper, to slap it up with one piece of tape on the inside of that door? Warning, watch your step. It's not that it was an issue of money. It's just that they couldn't be bothered to lift a single finger. And today you heard why. You heard about that person back in 2010, that employee who got hurt before Mr. Gilmore did. You heard me ask Mr. Geller about that employee of his who works for him, who is on his payroll, who sprained his wrist on those steps, Mr. Geller said, "Oh yeah, I think a lady might have gotten hurt. I don't remember her name." How do you know they failed to protect their employees? They don't even know who their employees are. Think about who they're really protecting. Simple steps. That's all it would have taken. The defendant didn't. And because they didn't, I expect that in just a moment, when opposing counsel comes before you, they're going to try to shift the blame anywhere else that they can. They might try to put it on Mr. Gilmore. They might try to put it on their landlord. I want to talk about that for a second. If they try to blame their landlord, they might show you a lease. They might talk about some legalese, but you will see in the jury charge the issue here is control. And control can be proven by a piece of paper, a contractual agreement. But control can be proven by an actual exercise. Think back to what Mr. Geller told you. He never saw the landlord use that area, inspect that area, clean that area, in that area. He only ever saw that area used for his company's business. Folks, that is actual control. You can listen to a piece of paper, or you can listen to reality. Simple as that. Reality tells us it was the defendant. It was the defendant's responsibility to protect their own employees. It was the defendant who didn't. Find them liable. Thank you.
Closing statement, Your Honor.
Go ahead.
Thank you. May it please the court. Your Honor, Ms. Forrester, good afternoon, members of the jury. Throughout this trial, Ms. Forrester told you that Chimes is solely responsible for Mr. Gilmore's accident. But the evidence has shown you that there are two other parties responsible for Mr. Gilmore's accident. Kermit Realty Group, the corporation that owns, controls, and maintains the loading area, and the plaintiff for what he did or did not do. Members of the jury, you are now being tasked with deciding who was responsible for what happened. Whether it was the landlord's failures, Mr. Gilmore's own conduct, or as the plaintiff has claimed, Chimes department store. Now, Ms. Forrester talked a lot about law, and I want you to remember the law when you go back to deliberate your verdict. I want you to consider the claims, and I want you to consider what Judge Seba will tell you at the end of this trial today. And the Judge Seba will tell you that you can assess liability against all three of these people, not just Chimes department store. And the plaintiff has claimed that only Chimes department store is responsible, but they have failed to prove that claim by a preponderance of the evidence, because Chimes acted reasonably and responsibly under the circumstances. But the actions of the landlord and the plaintiff himself caused this accident. Now, today you heard from the plaintiff himself and his involvement in this accident. He told you that out of 10,000 times of going out that back door, only once did he have a problem. In those 10,000 times before January 23rd of 2019, he never slipped, never tripped, never fell, and never had a problem with the lighting or the guardrail or the stairs or the concrete. In fact, we heard him say that it was a pretty regular occurrence that that light wasn't on. Yet, that did not stop, or excuse me, yet he still didn't bring his phone to act as a flashlight. The only light source that night was the light coming through the doorway that his coworker was standing in. Now, this door was not the only door that he could have used. We learned today that there were 2 doors that could have been opened, so that way light was coming out completely and nobody would have been standing in the way. The plaintiff told us that he had to climb around that door in order to get back into the store. But a safer route was available. Multiple safe routes were available. He could have opened the door as seen here in Exhibit 6. He could have had that door open fully, flush against the wall, completely clearing his path. He could have had his coworker open that far door, so that way nothing was standing in the way between him and getting into the store safely. But the plaintiff chose to go around that door. The plaintiff chose to take the only risky option. And the plaintiff should be held liable for their own actions. And the plaintiff also told us that there was no guardrail. That in his 10,000 times of going up and down those stairs, there was never a guardrail. As he said, you can't have guardrail on a loading dock. How could you? It doesn't make any sense. Now, Reese Geller testified today, and he told us that they would use that loading dock close to every single day. They use this loading dock to get deliveries. And during cross-examination, explained that a guardrail on the top of the landing area or on the stairs would have impeded using this area as a loading dock. Now, while this delivery contained smaller items, Mr. Geller told us that if there were bigger items, a guardrail on the staircase would be in the way. Now, we also heard today from Mr. Geller about the lease that they signed with Kermit Realty. And that lease said which areas that they did control and which areas were under control of the landlord. And we were shown those areas here in Exhibit 12. Displayed in the crosshatches and the shading of this area or of this diagram shows exactly which areas Chimes department store controlled. And that red X where the accident happened is the loading dock. Beneath that red X is not any crosshatches. Beneath that red X is under the control of the landlord and the landlord alone. Now, you heard today also you heard by deposition, from Kelly Danes. And she admitted that that area was used as a loading dock. And then you heard her admit that she doesn't know of any regulations that apply to loading docks. She doesn't even know if the regulations that she was citing applies to loading docks. The regulations that you are seeing here today, Ms. Danes cannot tell you if they apply to loading docks. And make no mistake, we can call it a landing area, we can call it a common area, we can call it a diner. It doesn't matter. What matters is what Chimes department store was using it for. And Chimes department store was using it as a loading dock. And the proof is in the pudding, members of the jury. Loading docks don't have the same regulations. You can't put a guardrail on a loading dock. And you can't have an expert come up and tell you that they don't know of any regulations, yet also tell you that they violated regulations. Members of the jury, if she doesn't know them, how can she say that they violated them? but who can tell you about regulations and who did tell you by deposition about the regulations was Ms. Perry Hayden, an OSHA inspector who went out and physically inspected Chimes department store. And when she went out there and did her inspection, she inspected even the outdoor area that they use as a loading dock. And at the end of that inspection, no citations were issued. And we heard what that means from Hayden, or excuse me, from Ms. Hayden. We heard that that means that there were no violations. And a violation in this case would have meant that Chimes department store had an unsafe condition. But no violations, no unsafe conditions, and no citations were ever found during this inspection. Now, she didn't just have to tell us this. She also told us that there are statutes and regulations that state there are no guardrails needed for a loading dock. She told you that OSHA says so, that OSHA says you do not need guardrails on a loading dock. Members of the jury, Ms. Forrester talked a lot about the law, but if the law, the ultimate authority of safety, which is OSHA, tells you that you are not required to have certain safety measures or certain installations, who can tell you any different? The bottom line is the law was complied with. Every single law about the loading docks were complied with. You also heard a lot about the light that was outside. But we heard today that that light was controlled and maintained by the landlord. And while the International Building Code states that there should be a light out there, there is one. There is a light out there. Unfortunately, there isn't a switch inside of Chimes department store for them to be able to turn it on. But members of the jury, the landlord did not maintain the areas that he was in control of under that lease that we saw today. And because of that, the concrete wasn't well maintained. The light wasn't taken care of. But the plaintiff also has some responsibility in this case. The plaintiff had other options on where to take his smoke break, what light source to use, and what door or doors would be open. The plaintiff chose to take his smoke break down by the dumpster, going down those stairs, instead of up at the landing with his other coworker. The plaintiff chose to only use the light coming from the inside of the store. And then on top of it, only chose to use half of that. The plaintiff chose to have the only door open that would block his path, instead of taking his smoke break at the top of the stairs, bringing out a flashlight or opening both doors to get the most light out there. And instead of opening a door that would have cleared his path, he made choices that put him at risk. Members of the jury, that's what actually happened on January 23rd of 2019. An accident caused by a series of mistakes and choices. And because of that, we ask that you follow the law, that you take the simple steps of assessing liability against Kermit Realty Corporation and the plaintiff himself, and find Chimes department store not fully liable. Thank you.
Any rebuttal?
Yes, Your Honor. Can I ask how much time I have remaining?
2 minutes and 55 seconds.
Thank you. The defendant wants to talk about Mr. Gilmore's conduct, so we'll talk about it. We'll talk about what he did that night. He walked down those stairs because he thought he'd get in trouble if he didn't. As he tried to walk back up those stairs, he leaned against that wall, tried to be as safe as he could. But folks, you heard what it was like that night. It was dark. It was windy. That door, it wasn't extending out into the walkway just for fun. Folks, it was there because his coworker was on the other side, bracing it against the wind. That door was open because it provided the only light they had out there, blocked as it was by his coworker standing in the doorway. You heard what the conditions were. But the defendant wants Mr. Gilmore to do the impossible, to be perfect, not to make a single mistake, not to take a single misstep on that narrow, crumbling ledge. They want him to be perfect. But folks, we want them to have done anything at all. Anything at all. To have left a flashlight by the door. To have stuck up one piece of paper. Watch your step. I want you to think about that. I want you to think about whose responsibility this was. I want you to think about Mr. Gilmore. And I want you to hold them liable. Thank you.
Judge, this is Aaron. Are we submitting ballots now?
Yes, sir. Do y'all know where to submit them?
Yeah, I've got mine done.
Okay, good. Yes, submit them, and then I think they'll let me know when we're ready to come on and give comments.
Very good. Thanks.
Uh-huh. Well, good job, guys. That was a really great round. I will defer to our jurors / scoring judges in the room to give you guys some first feedback. And then if there's any time and they don't cover anything I had, I will let you guys know. But whoever wants to start us off. Anybody? Aaron, Burke, I'm going to volunteer you since you're off mute
Sure.
already.
That's fine. I'm off of mute anyways. Good round, both of you, Tyler and Jenna. I really enjoyed the presentation. I think y'all did a good job of presenting the evidence and really being methodical about it. So slip and fall cases can be an interesting one to try, especially it makes for a perfect mock trial problem just because there's always contributory arguments that you're going to have. I've got just a couple notes. I'm going to try to keep it brief to get y'all out of here. So for defense, for you, Tyler, one thing that I think you might want to do in later rounds, if it comes up, is you had objected to the engineering expert on 702 grounds saying that they weren't proofed up properly. And if you notice, the judge, when she kind of made a ruling, she said, well, I would agree with the other side and let it go forward. I will tell you in real practice, that's your most important issue. So really preserve error on that, because I agree the job, I mean, I don't know what the transcripts are like, so you might not have had enough to prove up that expert to begin with. But if you really hammer it, you should have, one thing you can do is, Judge, I'd just like to be very clear. Are you overruling my objection and permitting the witness to testify? Something like that. Force her to rule. A lot of judges will say, well, let's move along, so you don't preserve error later. It also just shows you understand how it works. But then the other thing to do with an expert, you can ask to take that expert on voir dire to show that they're not qualified. So you can say, Judge, may I have a moment to take this expert on voir dire? I'll prove that she's not qualified under 702. And oftentimes the judge will allow you to do that, or they'll say, okay, Ms. Forster, I'm going to let you try to continue to prove this expert up adequately. So the voir dire thing can be really fun too, because you can kind of take over their case for a few minutes and beat up on their expert. Of course, it's not in front of the jury, but it gives you a good chance. For plaintiff, for you, Ms. Forster, I've got one thing that I like doing. So the original motion to keep the photos out was not a motion in limine. Motions in limine typically would require you to go back to the judge and ask for permission before and bring it up with the judge one-on-one with the opposing counsel. Since it was a motion to exclude, I always like trying to get the photo, whatever it is, but especially photos, I like trying to get them in again anyways. So give your key witness, your guy was kind of soft on, it was a bummer, my knee was messed up, and that's not your fault, that's just witnesses. But I'd give him the photos and say, what is this? What's this a picture of? Go through it, prove up the photo, and then offer it. Now it's her job to object again. If she doesn't object, then you get those photos in, because the judge isn't going to say, well, I'm going to make the objection for you. Now the judge may remind you that they ruled on it, but they can always reconsider in light of the evidence that's come in. And then typically it's going to be Ms. Jeffrey's job or the defense's job or the other side's job to try to keep those photos out and to object again to preserve. So, but I think y'all both did a great job. So good work.
We're going to stay in alphabetical order. I will give some very brief comments, Ms. Jeffries and Ms. Forster. I think y'all did a great job with a pretty dry topic. Some of these cases that we have in Top Gun are like a shooting murder case or, something really inflammatory. This was a, trip, slip and fall on some stairs, kind of boring. But you guys did a great job of making it seem real. I think you took it seriously and sort of internalized the idea of having a client, which is cool because a lot of times in these competitions we see people just going through the motions, and you seem like lawyers to me, and that was great. I will say for Ms. Forster, right from the start, you had good cadence and you were patient in the way you presented stuff. I've always had the problem in court that I want to put my whole argument out in the first 30 seconds, and I don't take the time to breathe and all that. So you've already got that. That's great. As far as the case strategy goes, you have the packet. I don't. But I would say the warning signs are not very effective for the plaintiff. This is, we've all been conditioned to laugh at plaintiff's lawyers who complain about not being warned about something that's just sitting right in front of you. And so if the guy's using those stairs all the time, he doesn't need a warning sign to know what's up. If the light doesn't work, he knows it. It's narrow, he knows it. All these issues. So I would try to steer it somewhere else. And one thing you might want to look up, and you might want to Google this, I don't know how much you can pull this into the problem, but a lot has been written about external doors opening outwards or inwards. So you may want to consider that. Go look it up. There's a ton of reasons why most external doors open inwards. There's weather reasons, there's security reasons. You can fiddle with the hinges if it's on the outside. So there's an oddity to this problem that they went and changed. They modified this area, but they didn't modify the doors to make it functional to both be a landing and a receiving dock. So that's something to consider. On direct, I would be more conversational, more like a talk show host, and less like just answering, asking the next question no matter what the witness says. Just have a little more give and take. Some of that is sidebar, but you can get away with it because no one's going to complain about some basic conversation in the beginning with a witness to warm them up. Ms. Jeffries, your cross was, I really liked your demeanor in your cross. You took the time to laugh with the person you were about to shred. And that's so hard to do. Like it's a really good way to make yourself likable, which to me is the key with juries. They want, once they like you, they like you. And so I thought you did a great job of dealing with that on cross. I would mock the warning signs. And both of you, my advice, and I'm sorry I'm giving way too many points here, but you got to think about why do they get motivated? It's because they control the standard in their community. So you got to kind of make this about, hey, jurors, what kind of world do you want to live in? Do you want to live in a world where the employer demands that you treat the customers like royalty, but they treat their own employees like trespassers? That's the plaintiff, right? And for the defendant, it's like, do you want to live in a world where the employer has to be the parent of the employee? And if you're a parent, are you supposed to, prepare the child for the road or prepare the road for the child? They're asking us to make every step this employee takes perfect. But that employee's been through that area 100 times. Why does the employer have to be the parent of this employee? They've got 2 feet. They can use them. They got eyeballs. So make it more about what world you want to live in. And that, I'll shut up. I've been talking too long. Good job.
Am I next, Trey? I get to jump in first. I'll be quick. I don't have the problem, so again, I don't want to dive too much into what I think the law is or how we deal with it, but just stylistically, things I like, things I didn't like. I'd tell you, I'll start with the plaintiff. Good job with the theme. You came back to it. If you're going to be the plaintiff, you pounded her in rebuttal. Got to do it in competition always. We do it in real life too. I mean, that's the way we do things. My only thing I'd say, again, to work on, and you already got this comment, was the direct, I thought, started out where it felt a touch scripted in the beginning. I don't know if it was or it wasn't. Some of that may have just been nerves, but it seemed like he answered a couple questions and you kind of asked him to follow up, even though he was either not really interacting with you that way. Defense counsel, Ms. Jeffries, great job, I think, taking charge kind of in the beginning. Hey, Judge, we've got some issues. We want to talk about some things. I always like 1 or 2 motions in limine, from a mock trial standpoint. Um, you know, I think you can come back. One of the things Ms. Forrester did well is, you know, she kind of danced around that. He shredded his knee and this and that. If you get the rulings the way you want them, I mean, I'd go back there and don't be afraid to object again and go, hey, Judge, hold on. We're now stepping over the line. Here's where we were. That's one thing I'd work on. You know, what I liked, I think your style is very good as far as a direct, you know, the problem. It seems like it's a little more conversational. Great job. Both of you did real well. I mean, I know it's a tough out of the chute on a Friday morning. Everybody that's here at judging, I think, has done this competition at least a couple of times. So, great job.
All right. Man, y'all are really, really good. Just fantastic lawyers. You're so much better than I was whenever I was a second year law student, and you're going to have wonderful careers. So I really, it's just everything that everyone said are great little tips for y'all to take along in this competition, but I'm just very impressed with y'all's skills. My only comment is y'all both got dealt some tough live witnesses, and they're tired Baylor law students, and you know, woodshed them hard. We lawyers have big egos and like to think that lawyers win trials, but more often than not, it's your witnesses that win your trials. And we're judging y'all on your skills, but we can't help but think about the woodshed process and getting those witnesses to liven up a little bit and show some personality. So I know you've only got a few minutes to coax them into the shape you want them to be in for testimony, but liven them up, give them some freedom to testify a little bit, and that'll pay off because the rapport that you'll have will be huge. But that's nitpicky. I mean, this is a mock trial competition. So great job. Very impressed. Good luck.
My few comments, I wanted to follow up on what he said too, and just kind of compliment you guys both on working really well with what you had as far as witnesses. And the one specific thing I would say for you, Ms. Forrester, I thought it was really great how you kind of turned his attitude and the things he said, you put that in your closing, which shows that you did that on the fly. Obviously, you didn't know how he was going to respond or any of that. And I thought that was pretty impactful. You both were, as everyone else said, you were really good. Your tone, it was very impressive. Y'all were very even, but very good to listen to. It's not like you were flat or anything. It was great throughout. The one thing, Miss Jeffries, I didn't notice this until closing, and this is the one thing I kind of thought of in the evidence. I don't know if I can make comments like this, but you kind of were reiterating, you know, he chose to do this, he chose to do this, he chose to do this. And there was a picture that was put up, and the day he fell, he walked around the door and it was open and there was that 12-inch gap. Yes, in one of the pictures you put up, I think it was exhibit 4, 5, 6, 7, something or the other. It shows that door that had been open that night, opened all the way flat against the building. I don't know how much of a difference that would make. I don't know. I think you maybe kind of mentioned it in your closing, but it's just something to maybe emphasize a little bit too. If, you know, these choices he made, why he could have opened that door up all the way. Why was it not opened all the way? Why was it only open to where it blocked the entire staircase? Because there's a picture of it completely open flat against the building. Just something to think about. I don't know if that's really going to make that much of a difference, but I didn't notice it until your closing, and it kind of hit me, and I was like, I didn't notice that before. But again, good job, guys. Best of luck the rest of the day and the rest of the competition.
Thank you all for your time, and good job, Jenna. It was a great round.
Yeah, same to you. Good luck to you. And thank you all so much.
Thank you, guys.
Take
Thanks,
care.
y'all.
Judge, are we going to be dismissed yet, or do you know? Hope you're on mute. I can't hear you.
Yes. Thank you for your service. I think you guys are good to go.
Okay, good.
Thanks, Judge.
Thank you all.
All right.
Take
Y'all have a
care,
good
guys.
one.
Golly. This camera makes me feel older than I really am. So, can you hear me, Tom?
I sure can.
I don't.
I dropped my speakers because I was on a conference call in the Gap and had turned off all my speakers then, so that I wasn't getting you initially, but I am now.
Well, I'm having trouble because I only see me and you on the screen. And
I see a slot for Sarah, but I don't see Sarah.
you just see me and you?
That's all I see right now. Okay, there's our witness.
Yeah, we're the witnesses.
Thanks.
All right, but I still should see, I'm supposed to see the whole screen, so I got to switch it to gallery view, I guess. It's on gallery. Okay.
Yeah, you're right.
Okay, do you see, how many people do you see on the screen now? Oh, there's Sarah. Okay. And I see Tyler, right?
Yes, Your Honor. I just wanted to confirm that you can both see and hear me.
I can see and I can hear you.
Perfect. Thank you, Your Honor.
Oh, I need to admit a couple more people. Okay, I'm gonna admit these people. But I'm in a different courtroom now and they put this camera so close, I look really ancient. Look, go.
There's some of
Realize I had that much gray hair, you know. All right. So basically I've got all right, okay. All right, and all right, how do you pronounce your name?
So my first name is Jack and my last name is a little complicated, but all you need to know is the R is silent. So it's Kasem C, like the letter C.
Sim C.
Yes, sir.
I didn't want to say when it said, I thought it would be Jack. You
Yeah.
know. All right. I guess I'm doing okay. All right, so I think I've got both the plaintiff and the defense, right? You can see 5 people on your screen. Everybody see 5 people?
Yes, Your Honor. I believe that we may be missing one witness. I'm not sure, though.
They were together in the same room.
Yeah, we're gonna alternate.
Oh,
They're,
okay.
they're contemplating their testimony jointly.
Is that a violation of the rule?
They're on opposite sides, but I guess, you know, what the heck, we can work out a deal. We'll just make it real complicated.
You're pretty unsettling.
Yeah, isn't it? All right. Okay. Whoa, I'm missing one judge. I'm missing Will Hicks. We got 1 minute. I'll give them the total of 1 minute. And then I'm gonna send the constable out with a contempt order, don't you think?
Of attachment.
Yeah.
I could always send the marshals. They tend to get their guy.
There you go. I had a judge one time that a witness had been excused and then an issue arose that was not known before the witness was excused. And another witness said something. And so we said, we need that guy back. And Judge Janice Graham Jack said, well, you know what? I have a tendency to agree with you. And the plaintiff's counsel said, well, the guy's getting ready to get on a plane. And she said, is he on the plane? And he said, well, I don't know. She turned over and she said to the marshal who happened to be in the courtroom, go get that guy and bring him back. Pulled him off of the plane and brought him back to the courthouse. Well, okay. That's the power of a federal judge. Oh, you know, cold all my.
She's also the judge. I believe Judge Jack is the one that found the entire Texas CPS system unconstitutional.
Unconstitutional. She sure did. Absolutely did. And she didn't have any problem saying that, for sure.
Well, you see, you think that William Wayne Justice does not live? He does.
That's exactly right.
We're different people.
That's exactly right.
You are all too young to understand these reference points. You'll have to hit the books and go see who these names are.
Yeah, there were several federal judges that I took my toothbrush when I went. So, and he happened to be one of them. Or the guy, what was the guy's name over in Fort Worth that?
Oh,
The one that nearly about put Sam Walton in jail. What was his name? He's still there, I think. But anyway,
yeah, he's just mean as a snake.
I took my toothbrush. Seriously, I took my toothbrush. I thought I was going to jail. I thought, man, I'm in trouble. So I didn't do anything wrong, folks. Okay, it's just the way you have to approach some of this. All right. I've given enough time, and because we are somewhat limited in the time period to get y'all done ready for tomorrow, we're going to go ahead and proceed. Okay. Tom and Sarah, y'all can turn off your. I think they want y'all's off, and cameras off.
McBride is your judge, I think.
What?
McBride, I think.
McBride, yes, that's exactly who it was. It was McBride.
I'll go mute now. Before.
All right. Okay, folks. And turn your camera off, Tom, so that they don't want the cameras on. So I got a note about that. I'm not exactly sure why. Okay. I'm Judge Dreyer. Are y'all, is plaintiff ready to proceed?
Yes, Your Honor. Would you like our formal introductions for the record?
Why don't you go ahead and do your formal introduction?
Yes, Your Honor. My name is Tyler Jeffries. My last name is spelled on the screen, but it is Jeffferes. I, along with my co-counsel, Marina DeRosa, represent the plaintiff, Jordan Gilmore, in this matter.
Thank you. Okay, defense, you ready to proceed?
Yes, Your Honor. May we also make formal introductions?
You may.
Good afternoon, Your Honor. My name is Jack Kasemsi, and I, along with my co-counsel, Jared Koenig, are here as representatives of the defense in today's case.
Fair enough. Do we have any pretrial matters to take up?
Your Honor, prior to pretrial matters, we do have a few housekeeping matters that we would like to address. May I proceed?
Yes, you may.
May we assume that all witnesses have been sworn prior to testifying today?
They have.
And these exhibits have been marked numerically. May the exhibits retain their original markings?
Yes.
If the court would like to hear arguments on objections, would you like us to preface those arguments with assuming we're outside the presence of the jury?
No.
Would the court like us to proffer experts before receiving their expert's opinion pursuant to Federal Rule of Evidence 702? These experts will be coming in through deposition testimony only.
I don't need you to proffer them. I do think it's helpful if you wouldn't mind setting the foundation for their ability to give expert testimony in order to give your opponent the opportunity to take them on board ours should they choose to do so.
So just to be clear on your ruling, Your Honor, you're fine with us just going from foundation to opinion without formally proffering the witness?
Correct. You don't have to interrupt your process to say we would offer them as an expert on X, Y, or Z. No, I do not see that need.
Okay, thank you, Your Honor. When laying foundation for exhibits, may we share those exhibits to the screen for the ease of the court and the witness, or would you like us to just invite the court and the witness's attention to the record?
If it's an exhibit that has not been admitted, then I want you to do it in a way that the exhibit is not shown to the jury prior to its admission.
Understood, Your Honor. After exhibits have been admitted, may we share those exhibits to the screen, and or would you like us to ask for permission every time before sharing those exhibits?
I would like for you in this proceeding to ask permission just so that everybody knows the direction we're going.
Understood, Your Honor. When impeaching or refreshing recollection, may we post the witness's deposition to the screen again for the ease of Your Honor and the witness?
Yes.
And finally, may we have the correct pronunciation of Your Honor's last name?
It is Dreyer.
Thank you, Your Honor. With that, we're ready to move to pretrial matters.
Okay, do you have anything pretrial defense?
Your Honor, we just have a pretrial motion.
Okay, and let's address the plaintiff's motions, if any. Do you have
Yes.
any?
Yes, Your Honor, we do. Your Honor, prior to trial today, the plaintiff was made aware that the defense in this matter has chosen a jury charge that does not involve Kermit Realty LLC. Therefore, we move to exclude any mention of Kermit Realty or their responsibility in this case, and it is wholly irrelevant. This would include excluding exhibits 11 and 12, which are a lease agreement and an exhibit to the lease between Kermit Realty and the defendant, Chimes Department Store.
Okay, I do not have the jury charge in front of me, but I'm assuming it's a standard definition of proximate cause.
Your Honor, in this case, the defendant was able to do an affirmative defense of either contributory negligence, including Kermit Realty, the plaintiff himself, as well as Chimes Department Store, or any sort of combination of those three. In this matter, the defense has done the affirmative defense that only includes the plaintiff and Chimes Department Store.
They've chosen that as the jury question.
That's correct, Your Honor. They've chosen that as their affirmative defense.
All right.
Your Honor, may I respond?
Yeah, you can respond. I don't have the charge in front of me.
Yes, I was going to pull it up if Your Honor would like me to.
Okay, please.
Okay, so this, Your Honor, is the charge that we today as a defense have chosen. Your Honor, as you can see, because the plaintiff is trying to prove that we were negligent, they're going to try to show all of these claims. Now, I'd like to preface my argument by stating that we have actually decided to only enter in.
Hold on just a second. Before you start your argument in
Yes,
this
sir.
regard, did the plaintiff have anything further? I just wanted to see the charge to make sure I understood the totality of the definition of proximate cause. And I appreciate you bringing that up, but I don't want to have you make your argument until she's concluded with what she's trying to say, if you don't
Yes.
mind.
Your Honor, I am finished with my argument. Just that it is wholly irrelevant because there is not any mention of Kermit Realty, and thus bringing them into this trial would only serve to mislead the jury.
Okay. Go ahead, defense. I'm sorry.
That's all right, Your Honor. So as I was saying today, we're here today because the plaintiff is bringing a negligence charge against the defendant. The only exhibit that we're actually going to try to enter, we're not going to try to enter exhibit 11, which is the lease in detail. The only exhibit we're going to try to enter is exhibit 12. And through exhibit 12, you can see the layout of the store, where the loading dock is, which is where the incident occurred, a marking on it. And then if you let it be entered, you can see there are cross hatches on it. And those cross hatches show which parts the defendant actually leases. All we're going to ask is that which parts the defendant leased, and if they leased the loading dock. And the defendant will show that they did not lease the loading dock. This goes towards disproving that the plaintiff's claims that we were negligent by showing that we failed to take care of this.
May I be heard, Your Honor?
You may.
Your Honor, the defense is attempting to prove that they didn't have control of this area by putting that control in the hands of the landlord, who hasn't been named in this matter. Therefore, it would only serve to mislead the jury, and any mention of Kermit Realty Group or that landlord is irrelevant.
That motion is denied. Anything else from the plaintiff's perspective?
Yes, Your Honor. Prior to trial today, the opposing counsel and I did meet, and we have stipulated to a number of exhibits, Your Honor. It is quite a lengthy list, so I can list those out for you now.
You stipulated in terms of their admissibility so that you can use them in opening statement?
That is correct, Your Honor. We stipulated to their admissibility, and we would be admitting them at this time.
Okay, then give me the list.
Yes, Your Honor. It is exhibits 2 through 4, 6 and 7, and then 16 through 35.
Is that true? Defense?
Yes, Your Honor, that is true.
And that's an understanding that exhibits that have been admitted, if I choose to admit them, they will go to the jury. Does everybody understand that?
Yes, Your Honor.
Jury's consideration.
Yes,
Right?
sure.
All right. And if there's agreement on it, then I'm going to go ahead and allow you to admit them, and they are admitted.
With that, Your Honor, the only thing we have left is asking Your Honor to take judicial notice of a couple of statutes. Those statutes are, I can pull them up on the screen if that is easiest for you, or I can give you the
Tell me.
citations. They are the OSHA statutes of 1910.23, 1910.24, 1910.37, and then the International Business Code of 1006.1 and 1005.2.
Is there agreement on that?
Yes,
Yeah.
Your Honor.
Okay, then that's granted.
Thank you, Your Honor. With that, we are ready to move to opening statements.
Okay, from defense perspective, do you have any motions?
Yes, Your Honor, we have one pre-trial motion. We are making a motion to exclude Exhibit 14. Would you like me to explain, Your Honor?
Please.
We are making a motion to exclude this because this document is, first of all, hearsay within hearsay. This is a recorded statement guide that the defendant used to interview a prior employee because of an incident. Secondly, Your Honor, we move to exclude it based on Rule 403. Your Honor, entering this exhibit would prejudice the defendant because it would confuse the issues for the jury. It could mislead the jury. Your Honor, this was made 9 years before the incident we are here today. Additionally, Your Honor, this incident that is recorded in here is not similar to the incident that we're here today for. In this incident, the employee fell down the stairs, and in our incident, the employee fell off a loading dock, which is completely different. And therefore, entering this would confuse the issues and prejudice the defendant.
Are the stairs part of the loading dock?
They are to the side of it, yes, Your Honor.
Okay. Lana?
Maybe heard, Your Honor.
Yes.
I will take those in turn. As to the hearsay objection, while there is 2 levels of hearsay, those all both of them fall under an exception to hearsay. First, the statements themselves that are contained in this document are opposing party statements if offered by the plaintiff. They are statements made by an agent under 803D2. Thus, that satisfies an exception to hearsay because they are statements made by an employee of Chimes department store. As for the document itself, Your Honor, it is a business record, and it is kept in the regular course of business. We have a custodian that can testify to that, and we also have certification that it is a business record that is commonly used and will be recorded at the time or near the time that an incident occurred. As to the objection on 403 grounds that it would confuse and mislead the jury, this goes to notice, Your Honor. And there was 9 years between this incident and the prior incident. But in those 9 years, nothing was done, Your Honor. This goes to notice to show that those stairs next to the landing dock, in fact, the stairs are completely attached to the landing dock. It's one concrete block, Your Honor, that they had noticed that these stairs are dangerous and that employees have fallen on them before. This entire document completely goes to notice and knowledge that this dangerous condition.
Anything further from the defense?
Your Honor, I would just like to quickly point out that the statements made in this are made by an employee that is not here today, that we cannot ask these questions about, and the truthfulness of these statements cannot be tested today or guaranteed today.
May I be heard, Your Honor?
I think I've heard enough. Here's what I'm going to do. I'm going to grant the motion in limine. Okay, and by doing so, I don't want anything mentioned before the jury, obviously. About it, but you're free to address it. I'd like to see what the evidence is and how it plays out before I determine. I don't, the hearsay objection, I'm not concerned about. And, but I want to make sure that it is admissible and relevant and not excludable under some other grounds. In other words, I'm not concerned about the hearsay. I think the hearsay is overcomable. But I want to give you the opportunity to see how this evidence developed. So the motion in limine is granted. I am not granting any kind of motion to exclude it, to keep it out of evidence completely forever and ever.
Yes, Your Honor.
Everybody clear?
Yes, Your Honor. At this point, the defense is ready to proceed.
Good. Anything further?
No, Your Honor. With that, we're ready to move on to opening statements.
Okay. Plaintiff, go ahead and give your opening statement.
Your Honor, may I have a moment to set up the well?
You can have a moment.
Thank you, Your Honor. Are we ready to proceed, Your Honor?
You may proceed.
Thank you. Your Honor, opposing counsel, good afternoon, members of the jury. May it please the court. Safety first. We've all heard the phrase safety first. We've heard that phrase again and again over the years because those words are important to remember, important to follow, important to live by, because safety should always come first in the home, in the school, and even in the workplace. But unfortunately, when it comes to some people, some businesses, and some employers like Chimes department stores, safety doesn't come first. In fact, doing it the easy way is the only way that Chimes does business. And because of that, their most dedicated employee was injured. It is because of that their most dedicated employee, Jordan Gilmore, fell on January 23rd, 2019. He suffered serious injuries because of Chimes' negligent conduct and complete indifference to Jordan's safety. Today, members of the jury, you have to decide if the defendant should be held responsible for their negligent conduct or if they should just get away with it. And in order to make that decision, you'll have the testimony of witnesses, the evidence presented, and the law given to you by Judge Dreyer. Judge Dreyer will tell you that the defendant department store has a duty to provide their employees with a safe place to work, to provide them with protections and precautions to ensure that each of their employees are safe. And today we will prove by a preponderant or by a greater weight of the evidence, more likely than not, that the defendant breached that duty. And we'll prove that by establishing the three key facts. First, that there was a dangerous condition at the defendant's store. Second, that the defendant knew of the dangerous condition at the defendant's store. And third, that the defendant failed to protect Jordan from that danger. In fact, the defendant directed Jordan and all of their other employees to work in that dangerous area on a daily basis. So let's discuss that first point, that there was a dangerous condition at the defendant's store and why it was so dangerous. You'll learn that many years ago, the defendant moved into a building located in a mall, and that they decided that they needed some construction done. And in fact, we will hear that the defendant directed the landlord to construct a concrete loading dock in the rear of the building by removing a safety railing around an emergency door, which violated various safety codes. But that wasn't the only unsafe condition. You'll learn that the concrete on the loading dock itself and the stairs leading to that loading dock became worn and worn after years and years of use. They began to crumble. In fact, the concrete became so worn, so hazardous, so unsafe that it was only a matter of time before someone was injured. Which brings me to my second point, that the defendant knew the area was dangerous. And why do I say that? Because we will hear from the owner himself that he went out to that dock multiple times over the years, that he's seen the condition of that dock, and that employees have complained about the condition of that dock. But we will hear that what the defendant did after learning about the condition, after seeing the condition, in one word, nothing. They didn't repair the concrete platform. They didn't repair the concrete stairs. They didn't put up any type of safety railing. They didn't even put up a sign warning the employees of that dangerous condition. They didn't do anything. And not only that, we will learn that the defendant was specifically told that additional lighting was needed in that area. And what did the defendant do after learning that? Once again, nothing. They didn't put up additional lighting. They didn't repair the one light that they had out there. They didn't do anything to make that area safe. Instead, the defendant directed their employees to work in the dock area, to take breaks in the dock area. And in fact, you'll see a memo today that the defendant sent to their employees, directing them, demanding them to only use that loading dock for their breaks, which is the reason why Jordan was in that location on January 23rd, 2019. Now, Jordan Gilmore will take the stand today, and he will tell you that he went out to the loading dock. He went out there to take a short break. And before I go any further, I would like to introduce you to Jordan. Jordan, would you mind turning your camera on? Thank you. This is Jordan Gilmore. He's born and raised right here in Waco, Texas. And he's an active churchgoer who participates in Sunday school and a Wednesday book club. He is Chimes Department Store's most dedicated employee for the past 10 years. Thank you, Jordan. You can turn your camera off. After 10 years of working at Chimes Department Store, we'll hear that Mr. Gilmore went to take a break from his shift, from his 8-hour-long shift. He went out there about 7 p.m. at night, along with another employee. Unfortunately, because of their poor lighting conditions, because of the crumbling concrete, because of the poor condition that the steps were in, and because the defendant ignored those hazards and let safety fall through the cracks, Jordan fell onto the hard surface below, where he suffered serious and permanent injuries. injuries that could have been avoided, injuries that should have been avoided. If the defendant had only protected Jordan from that danger by putting safety first. But instead, the defendant put their own aesthetics first, their own concerns first. And the defendant failed to put Jordan Gilmore, their own employee, and safety first. Which is why at the end of this case, after you've heard all the testimony and seen all the evidence, I will come before you and ask that you return the only verdict based on the law and facts. A verdict finding the defendant corporation, Chimes Department Store, liable. Thank you.
Your Honor, may I proceed? I'm sorry, Your Honor, you're muted. I just want to make sure it's okay.
Sorry.
You're good.
You may proceed.
May it please the court. Members of the jury, we are here today because the plaintiff keeps trying to slip on by. You'll learn today that the event that occurred that has brought us here today was when a plaintiff tried to slip on by a door that was blocking their path. Because they tried to slip on by, they fell off. Now the plaintiff is here today trying to slip on by responsibility. Responsibility for their choices and the consequences of their choices that have brought us here today. And if we let them slip on by today, slip on by their responsibility, then a local family business is going to have to suffer. I want to talk about that local family business. That local family business, Chimes Department Store, is the defendant in today's case. Now, if you live in Waco, you know about Chimes Department Store. It is a locally owned, family-owned store. Today, you're going to get to hear from Reese Geller, the current owner. The cool thing about Reese Geller's journey there is that Reese Geller's grandpa actually opened Chimes Department Store in Waco. It was a huge success. The grandpa did great business, and then he passed it on to Reese's parents. Reese watched all of this happen, and when it was time to decide where to go to college, Reese decided Baylor. He didn't go somewhere afterwards to get his MBA. No, he wanted to be here. He wanted to be in with the family business. But when Reese graduated from Baylor, Reese didn't automatically become the CEO. Now, Reese Geller started out as a buyer because Mr. Geller wanted to get to know that company from the bottom up. Mr. Geller wanted to earn his right to be the owner of that company. And that company was so successful that in 2005, it moved to its current location on Bosque Avenue in Waco, Texas. This legacy could all be ruined just because the plaintiff won't take responsibility for their choices that brought us here today. I want to talk about what today's case is really about. Today's case is about an employee who on one of their breaks, who knew it was pitch black outside, who knew that it was a cold winter day, who knew that it was windy because a winter day in Texas, well, it's usually going to be cold and windy, and went outside still to take a smoke break, even though they'd been working since 12 p.m. That employee is a plaintiff in today's case. When the plaintiff went outside to take that smoke break, the plaintiff made some choices. Rather than standing on the loading dock with their friend that they came out there with, they decided to go down these steps. They took their smoke break, and as they're making their way back up the steps, their friend is opening the door halfway, holding it. Now, the plaintiff could have made multiple choices at this moment when they're making their way up the stairs and they see that the door is only half open. The plaintiff could have grabbed the door and opened it all the way and made its way up. The plaintiff could have asked their friend, "Hey, can you close the door while I come up those stairs?" But the plaintiff didn't make either of those choices. The choice that the plaintiff decided to make was to try to slip on by that door that was blocking their path. And unfortunately, because they made that choice, they fell off a loading dock a couple feet up from the ground. Now, we're not here saying that you shouldn't feel bad that the plaintiff was injured. We are sorry the plaintiff was injured, but the plaintiff was injured as a result of their own choices, members of the jury. When you hear from the plaintiff today, the employee, I want you to think about two things. First, I want you to think about the plaintiff's familiarity with that back area. Because as you're going to hear, members of the jury, that plaintiff went out those doors, down those steps, and back up those steps thousands and thousands of times. That plaintiff knew that it was a loading dock. That plaintiff knew that there wasn't railing on a loading dock, because how else would you load something? And they still made the choices they did that night. And that's the second thing I really want you to pay attention, is all the choices the plaintiff made that led up to the accident. Today, we also want you to get to know Reese Geller, who owns the defendant company in today's case. We want you to learn about their family and learn about the circumstances of this loading dock that Chimes department store used for many, many years. And then we're gonna have you hear from Perry Mason, an inspector for OSHA, who inspected this loading dock, the loading dock that met all the standards. Today, the plaintiff has a burden of proof. They have to prove to you by preponderance of the evidence 3 things. First, that the condition in question posed an unreasonable risk of this loading dock. Second, that we, Chimes department store, knew or should have known about this unreasonable risk. And third, that Chimes department store failed to protect their employees. And as you'll see today, they're not going to be able to meet that burden. But what we will show you today, members of the jury, is that we're here today because of the plaintiff's choices. And in order to make sure that the plaintiff can't slip by their responsibilities, slip by you, we're going to ask that you find them liable.
Plaintiff, you ready to call your first witness?
Yes, Your Honor. Plaintiff calls Jordan Gilmore.
Gilmore, you've been sworn. I believe.
Good afternoon, Mr. Gilmore. Could you please introduce yourself to the jury?
Sorry, first, can you not hear me? Good.
Yes, we can hear you, Mr. Gilmore. And if at any time you can't hear me, you just let me know and we can make sure that we get that fixed.
Okay. My name is Jordan Gilmore.
And how old are you, Mr. Gilmore?
I am 48 years old.
Where do you live?
Waco, Texas.
And are you active in the community of Waco, Texas?
Yes, absolutely. I'm very involved with my church, Seventh and James Church, Baptist Church here in Waco. I do a lot of events with them and very close with everyone there. Love to participate, and we also have a book club as well, and I'm also very involved in that Wednesday nights. So yes, very involved in the community here.
And do you work at all with any of the free time that you may have?
I'm currently unemployed at the time, but I used to work at Chimes department store.
No, I would like to talk with you about your work at Chimes. But before that we do that, can you tell us why you're here today?
Yes, so I used to work at Chimes store, and unfortunately, I was injured on the job, and I required surgery on my knee. My knee was had to be completely replaced. And when I went after I was injured and I went to talk, I was fired essentially.
Objection, Your Honor. This case is bifurcated today on liability and damages. The witness is going to the damages as per the knee replacement and the fact that they came back to work and they didn't have a job for them. This has nothing to do with proving liability and therefore is improper for today's case.
Move on, counsel.
Yes,
Absolutely, Your Honor. Now let's talk a little bit more about the day of your fall. What date was that?
January 23rd, 2019.
And what time did your shift start that day?
So I was doing the afternoon shift, the 12 to 8 p.m. shift.
What do you do while you're on shift?
So I work the cash register towards the end, and I help the people there who are checking out and need to find something in the store.
Now, on the day of the fall, what were you doing prior to falling?
So I was working, and then I went to take a smoke break.
And where did you go to take this smoke break?
So they have us go to the back. Obviously, they don't want us to go to the front. They don't want the customers to see us. And the back is a loading dock. So that's where I went.
You said they don't want you to be in the front. Who's they?
The store owners, the store managers.
How did they tell you that they didn't want you to be in the front of the store?
They simply, I guess they just said, they didn't necessarily not say that. They said, if you need to take a smoke break, it has to be at the back.
And how did they communicate that information to you? Did they say it in a meeting or send you any sort of document?
They sent us a memo.
Would you recognize that memo if it was shown to you today?
Yes.
I would like to invite your attention to Exhibit 1. Do you see that, Mr. Gilmore?
I do not see it.
Mr. Gilmore, you do have an electronic trial notebook.
Yes.
Exhibit 1 should be located in there.
Yes.
What is Exhibit 1?
It is the memo that was sent to me from the management there at Chimes.
So just to be clear, it is a memo sent by the management at Chimes department store?
Yes.
What date was this memo sent on?
I believe it was it was before January 23rd, well, way before January 23rd when the incident occurred.
And this is a fair and accurate copy of that memo that was sent out to you?
Yes, it is.
Your Honor, at this time, we would like to move what has been pre-marked for identification as Exhibit 1 into evidence as Exhibit 1.
Any objection?
No, Your Honor.
It's admitted.
Your Honor, may my co-counsel publish Exhibit 1 to the screen?
Yes.
Thank you. Thank you. Mr. Gilmore, can you see that?
Yes, I can see that.
And on this memo, where does it say for you to go to take a smoke break?
So in the first paragraph, it says, as you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. This is the only place you should take smoke breaks on the premises. It's very
and now, go ahead, I apologize.
No, it was very specific.
And now above that, do you see the date that this memo was sent out?
Yes, July 1st, 2015.
Thank you. You can take that down, Mr. Rosa. Now, when you went out to the back area, was anyone with you?
Yes. The person I work with, Riley.
And about what time did you go out to the back area?
So it was about 6:30, 6:37, around that time.
And
PM.
what was the lighting outside like at that time?
So it was cold, and the sun at that time goes down pretty early. So it was dark. It was really dark at that time.
Is there any artificial lighting out back there, such as a light or a lantern of any sort?
No, there's not. So there was issues because the light switch to turn the light on was actually in the Tractor Supply store, which we didn't have access to. So no, there was absolutely no way to have artificial. The only way we could was to leave the door open, propped open. That was the only way we could get light from inside the store.
And did you do that on January 23rd, 2019? Prop the
Yes,
door open?
we kept the door open.
And have you done that before?
Yes. On our smoke breaks, yes, we've kept the door open.
Did you ever tell anyone about the light that was out?
Yes, we complained many times, and they said that there was nothing they could really do. There were other things that they needed to take care of.
And so after you went out back to take a smoke break, where did you actually take your smoke break?
So I stepped down the loading dock. So it was by the loading dock, stepped down, and that's where I took my smoke break after I stepped down from the loading dock.
So you didn't stay on that platform?
I did not.
And why is that?
I just didn't want the smoke from me smoking to get into the store. I didn't want to get in trouble for that.
You mentioned that you went down the stairs. What did those stairs look like?
They were just like falling apart, like really, really old stairs. There was no markings on them. They were just plain like concrete steps.
And while you were smoking, where was Riley Huntsberger?
She was on the doorway. I believe she was holding the door open because there was a lot of wind that night, as I recall. And I think she didn't want it to close, and also we needed the light. So she was standing kind of in the doorway.
Your Honor, we have what has been admitted into evidence as Exhibit 4. May we post that to the screen?
Publish it, yes.
Thank you. Mr. Gilmore, can you see that?
Yes.
And what are we looking at here?
This is the door that leads to the loading dock that that Riley was holding open, and it opens outward.
And is this how that door looked on January 23rd, 2019?
Yes.
In relation to the stairs, where is this store located? Or excuse me, where's the door located?
So it opens out towards the stairs, and the stairs are to the right, I believe.
So would it be fair to say that where that hole is on the left-hand side is the edge of the stairs?
Yes.
Thank you, Mr. Rosa. You can take that down. Was that door propped open with anything that night?
No, Riley was holding it open.
Do you know why she was holding the door the way that Riley was?
So there was very strong wind, and I believe she did not want the door to shut.
Now, we haven't talked about the actual fall itself. So what happened? Excuse me. After you finished smoking at the bottom of the stairs, what did you do?
So I decided to go back up. Obviously, the door was in the way. So I started to go up, and I was using my hand against the wall to kind of hold myself. And Riley, obviously, she was holding the door open. So I kind of went a little to my right and around, and that's when I slipped. It was kind of slippery. And I fell backwards on my rear.
And how did you land before falling on your rear?
So I hit kind of like my hip and my knee when I was falling. And Riley actually tried to help me when she realized that I was falling, tried to grab me. But unfortunately, I fell pretty hard.
Did you tell your supervisor or your boss about this injury?
Yeah, so I got up and it was immediate pain, just immediate pain. And I went back to the store. I was holding myself against the wall, and Riley kind of helped me a little bit. But then for a minute, I felt fine, like I thought it was fine. And I went to talk to the manager about what happened.
Did you tell them how it happened?
Yes, I did. And their response was, we should have fixed it a long time ago. I don't know why there wasn't, why they didn't have any railing. Like she goes, I've spoken to the owners and they said they had other things to worry about, is what they said.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. I just want to clarify something really quickly, Mr. Gilmore. You actually never told your management about the fact that you didn't like that there was no railing. Isn't that right?
Yes.
You only complained a lot about the lights to them.
Yes.
Never the fact that there weren't railing.
Nope.
Now, I want to talk about how often you actually went out on that loading dock. You're a smoker, Mr. Gilmore.
I was, yes.
At the time of the accident, you were a smoker.
Yes.
You were a smoker when you worked at Chimes Department for 10 years.
Yes.
You smoked a pack a day.
Yes.
20 cigs a day, usually.
More or less, yes.
And you took a smoke break every single day at work, didn't you?
Yes.
You also would take out the trash once or twice a day.
Yes.
And by your estimate, you went out those doors and down and up that loading dock 20 times a week, right?
Yeah, about, yes.
And so during your 10 years there, you went out those doors, up and down those stairs thousands of times, didn't you?
Yes.
And before this incident that happened on January 23rd, 2019, you never fell down those stairs.
No.
You never fell off that loading dock.
No.
On the day in question, your shift was from 12 to 8 p.m.
Yes.
According to you, the sun was up the first 6 hours of your shift.
Yes.
But you chose to take your smoke break at 7 p.m.
Yes.
You knew it was going to be dark outside, didn't you?
Yes.
You knew that the Chimes department didn't control the light out there.
Yes.
You knew that there wouldn't be any light out there.
Yes.
And you knew it was going to be cold because it was winter.
Yes.
So you really wanted to make that smoke break really quick.
Wouldn't say quick. It was just normal smoke break.
You didn't want to just go in and out quickly because it was cold?
I mean, I had a jacket on it. It was fine. Just needed to take my smoke break.
When you went out there with your friend Riley stayed on the platform, didn't they?
Yes.
You chose to walk down those steps.
Yes.
The steps weren't lit up, were they?
No.
But you didn't fall going down those steps, did you?
No.
You didn't fall going up those steps.
Going up the steps?
Did you fall on the steps that day? That's what I'm saying. Going up the steps, did you fall?
When I got to the top, no, until I got to the top, I guess is when I fell.
Yeah, that's right, because you fell off the loading dock, didn't you?
Yes.
Your friend Riley was opening the door, weren't they?
Yes.
And you're aware that that door can be pushed all the way against the wall, aren't you?
Yes.
In fact, when you went up those steps after your fall, that night, Riley had pushed the door all the way back against the wall.
Yes.
And you had no trouble going up those steps with that door all the way open.
No.
But you didn't ask Riley to push the door all the way open when you went up.
No.
You didn't ask Riley to close the door so you could go up those steps.
No.
You chose to go around the door, right?
Yes.
And I want to pull up what was previously pulled up, which was Exhibit 4. You saw that's how much space with the door halfway open, didn't you?
Yes.
Right here.
Uh-huh.
And you chose to fit around that.
Yeah, I'm a pretty thin guy. I thought I could fit around.
Now, when you fell off of 2 to 3 feet platform,
Yes.
and it was off the loading dock, wasn't it?
Yes.
But after you fell, you got back inside without a problem, didn't you?
No. No.
You got up. Oh,
Sorry. I was in a lot of pain and it took me a little bit to get up. And for a second, it felt fine afterwards, but it was pretty painful. So I wouldn't say, yeah.
You did get up those steps, didn't you?
Yes, I did. Correct.
And you went back to work.
Yes.
No further questions, Your Honor.
Redirect.
No, Your Honor, we just asked that this witness be excused.
Witness is excused.
Thank you, Your Honor. With that, the next witness we have is Kelly Danes, who will be testifying through deposition. And if it is all right with Your Honor, my co-counsel will act as a Ms. Danes for the purposes of reading the deposition in.
That's fine.
Beginning with page 2, lines 6 through 7. Question. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Dane.
And moving down on the same page to lines 12 through 24. Tell us about your education.
I have a Bachelor's of Science in Medical Engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure, I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person builder from the Scaffold Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically some continuing education and additional certifications.
I noticed that your CV lists you as a PE. What is that? We are now going on to page 3, beginning with line 1 in Ms. Dane's answer.
It stands for professional engineer.
On the same page, we're going to lines 8 through 21. Question. In which states are you registered as a professional engineer?
I'm currently registered in California, Texas, Wisconsin, Virginia, Louisiana, Idaho, and Washington. And I'm also registered with the National Council of Examiners for Engineering and Surveying.
What do you do professionally?
I'm the president of Danes Engineering, LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
We are now moving to page 4, line 5 through 10. Question, do you testify mostly for plaintiffs or defendants?
Both, pretty even, really.
How long have you been in business as Dane Engineering's LLC?
I've been doing that for the past 10 years. Prior to that, I worked for another guy that had his own consulting business, basically doing the same thing, but just doing it for someone else.
And on that same page, we're going to lines 14 through 20. Over the course of your career, how many incidents have you investigated?
Over 60.
How many times have you been deposed?
About 20.
And how many times have you testified at trial?
Twice prior to this.
We are now going to page 5, beginning with line 15 through line 22. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, and a number of provisions from the International Building Code. And I conducted an inspection of the location of the fall and took pictures of that area.
We are now going to page 6, lines 2 through 5. Question, based on your review of those materials combined with your own supposed expertise in engineering, have you come to any opinions in this case?
Yes, I have.
We are now going to page 8, lines 16 through 24. And I apologize, Your Honor. It looks like I'm having a technical difficulty. May I take a brief moment?
You may.
I apologize. 1 second. I apologize, Your Honor. It looked like my electronic copy of the record has been corrupted, so we're going old school. So again, we are doing page 8, line 16 through 24. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and the landing in question, and the facilities in question must be in compliance with those codes and regulations.
What is the basis for that opinion?
Well, in regards to the International Building Code, the City of Waco adopted that code and incorporated it into its own city ordinances on March 20th, 2001. The OSHA regulations were enacted into law in 1970. So both the IBC and the OSHA regulations would apply to whoever was responsible for the maintenance and repair of the area where this incident occurred.
And we are now on page 9, going from line 11 through, or excuse me, line 9 through 24. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of light switch to turn on the light above the stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
We are now going to page 11, lines 6 through 24, and this will continue onto page 12, lines 1 through 14. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chimes store. So there was no way for employees to turn that light on when they were outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Have you ever seen that light above those stairs turned on at night? And do you know how much light it would have provided?
No, I've never seen that. I just know that it wasn't on and there was no switch for it.
What's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
With that, we'll move to page 13, or excuse me. I apologize. Again. Sorry, why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed sides, which is obviously dangerous.
Do you know if there was ever a guardrail on those stairs?
Yes, there was, and it was removed at some point.
How do you know that?
Well, first, you can just look at the photographs and see where the guardrail used to be on those stairs. You can see the broken off piping in the concrete. But second, there's a photograph showing a guardrail on those stairs and that landing.
That will move to page 13, lines 16 through 24, continuing on to page 17, lines 1 through 11. All right, anything else?
Let's take a look at OSHA 1019.24H and IBC 1012.1. 1910.24H requires railings on all stair platforms, and 1012.1 requires guardrails on all landings that are located more than 30 inches above the ground. In this case, as you can see from the photographs, I measured the distance from the ground to the top of that landing, and it was 34 inches. So this landing would be subject to both standards. Again, like we discussed earlier, this landing had a guardrail at one point and it was removed. And depending on exactly where the plaintiff fell, if the stair handrails didn't provide enough protection, then a guardrail around the landing would have given him something to grab onto to keep from falling.
Do either 1910.24 or 1012.1 apply to loading dock?
They don't mention loading dock specifically, but this wasn't a loading dock.
Why do you say that?
Well, just look at how it was used. Employees use this area to throw trash in the dumpster and use it to take some smoke breaks. So this wasn't just a loading dock.
And moving on to page 14, line 22 through 24, continuing on to page 15, line 1 through 6. Anything else?
IBC 1005.2 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully open, the door shall not project more than 7 inches into the required width. When the door is open like it was at the time of this incident, it obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the plaintiff fell.
Thank you. That includes the reading of this deposition for the plaintiff, Your Honor.
Defendant, do you have anything from this depo that you want to read?
Yes, Your Honor.
Okay.
We will be reading on page 14, lines 12 through 21. You would agree, though, that this area was used by Chimes as a loading dock at times.
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
At this time, we're done reading lines to this deposition, Your Honor.
Anything further from this witness?
And no, Your Honor, and with that, the plaintiff submits their case.
You're resting.
Yes, Your Honor, the plaintiff rests.
Okay. Do y'all need a 5-minute break or do you want to proceed forth?
We would appreciate a 5-minute break if that would be okay with you and the jurors, Your Honor.
It's certainly fine with me. We'll take 5 minutes and be prompt in your return.
Yes, Your Honor.
And Your Honor, could we get a time check when we return?
If I'm capable of doing the math, the answer is yes. So
Thank you, Your Honor.
Oh, you made an inquiry about the time. Plaintiff's 28:25. Defense 13:16.
Your Honor, just to be clear, is that left or is that used?
That's how much time you've used.
Thank you, Your Honor.
You have plenty of time. So both of you. Defense, you ready to proceed?
Yes, Your Honor, if our witness is back. Mr. Geller.
Yes,
Yes, we're here.
May I proceed, Your Honor?
you may proceed.
Good afternoon, Mr. Geller.
Good afternoon.
Please introduce yourself to the jury.
My name is Reese Geller. I am a Waco resident and I own and operate Chimes.
Do you have a family here in Waco?
I do. I have a wife and I have 3 kids.
You said that you work at Chimes. How did you start working at Chimes department store?
So Chimes has been passed down in our family through a couple generations now. And I started at Chimes as just a basic buyer, just scouting out merchandise to fill the shelves because we are a retail store. And that's where I started. And I worked my way up, did the things I needed to do to get to where I am today.
When you say it's a family store, can you explain how your family's tied in with Chimes?
Sure. My grandparents opened it up. And then my father also worked there. And then that's how I was introduced to the business, working there as well. When my father took over, it was a big family accomplishment. And now as I run it, it also is a something our family is proud of.
Where is Chimes located right now?
It's in Waco off Bosque Avenue, just a small storefront.
Have you guys always been at the location of Bosque Avenue?
At this moment in time, I believe so. I don't think we've moved the store.
Can you not remember when you
I can't remember. I cannot remember. I'm a little nervous on stand, so I can't remember all the facts of the past of the store.
Did you remember this when you gave your deposition?
I believe I spoke about it in the deposition as well in a less environment.
Would looking at your deposition help refresh your memory really quickly?
Yes, it will.
Do you have your deposition with you, Mr.
I
Geller?
can pull it up here on my side screen. Yes, I have it right here in front of me.
Mr. Geller, can you locate where it says what year you guys moved to the Bosque Avenue area?
It's coming back to me now that I'm remembering. I think we moved in no, hold on. I want to be correct. How far? We definitely moved in.
Mr. Geller, if you would direct your attention to page 4, I believe that would help recollect your recollection. At the top of page 4.
Yes, we moved there back in 2005. Yes.
Now, Mr. Geller, I want to talk about the accident that has brought us here today. Are you aware why Chimes is a defendant in this case?
I am.
What do you know about it?
From my understanding is during a smoke break, one of our employees fell off a loading dock that we used pretty consistently and injured his knee.
Now, this loading dock, does Chimes own this loading dock?
We do not own this loading dock. It is a public use loading dock for the facility that we rent from.
Now, how do you know that you don't own this loading dock?
In the lease, it defines public areas, and I believe it was marked with I was shown an exhibit where it was marked with a red X during my deposition of the area considered public use, which would be where the loading dock was located.
Would you recognize this diagram that you showed during your deposition if I showed it to you right
I would.
now? Actually, do you have it with you? We need to establish that.
Yes. Do you by chance remember the exhibit number?
Yes, Mr. Geller, it's exhibit 12.
Okay, yes, have it in front of me now.
Is that diagram?
That is that diagram, yes, ma'am.
And has it been altered in any way since you last saw it during your deposition?
No.
At this time, Your Honor, the plaintiff or the defense moves Exhibit 12 into evidence.
Any objection?
No objection, Your Honor.
It's admitted. You may proceed.
May we publish it to the jury, Your Honor? By screen sharing.
You may.
Mr. Geller, is this that diagram you're talking about?
It is.
And what is that red X right there?
That is the location of our loading dock.
And what do these cross-hatched lines indicate?
The property that we rent, according to our lease.
Thank you. No further questions about that. We can move on now, Mr. Geller. So that loading dock, does Chimes use it?
Oh, every day, multiple times a day.
What's its primary use for?
Loading and unloading trucks. Based on when I was a buyer, we used to have trucks come in to unload and all their merchandise so that way we could sell it in the storefront.
Do employees use the loading dock for any other purpose?
Its primary purpose is for loading and unloading. I do not require our employees to use that loading dock for any other purpose besides loading and unloading.
And Mr. Geller, I just want to ask you, why isn't there railing around that loading dock?
We asked to remove the railing because our sole purpose for that plat was to use it as a loading dock, in which case the railing would have rendered the loading dock very difficult to use if our employees would have to walk down the stairs, around the rail, go up on top of the truck that's lifted, when the truck could just back up directly to the loading dock where it's a flat, continuous platform into the truck for loading and unloading.
And Mr. Geller, I'm going to show you what's already been entered into evidence as Exhibit 1. Is this a memo from one of your employees?
It's from management to the employees, yes.
And does this say anywhere that the loading dock is to be used as a place for smoke breaks?
No, this memo was sent out to deter people from smoking in the front by offering the back as a place that they could smoke if they so chose.
No further questions at this time, Your Honor.
Cross-exam.
Yes, Your Honor. Good afternoon, Mr. Geller.
Good afternoon.
You just described Chimes department stores, right?
I did.
You described it as a family business.
I did.
But it's not just a family business, it's a corporation.
It has family roots that employs non-family people.
Now, I'm not asking you about the roots. I'm asking you if the department store is a corporation, and it is, right?
I believe so, yes.
And as the owner, you're the one that's in charge of this corporation.
Yes,
You're the one that makes ultimate decisions.
I am.
You would agree that safety is important to you?
Yes.
That your
Absolutely.
employee safety is important to you?
Of course.
That providing a safe workplace is important?
Yes, yes, ma'am.
Following safety regulations is important?
Yes.
You would agree that your company should prioritize safety?
Yes, we do prioritize safety.
Let's talk about how Chimes has prioritized safety in the past. Now, you worked with Chimes, or you worked at Chimes when the company moved back in 2005, right?
I did.
They needed a bigger space,
Yes.
and so they moved to the strip mall.
Yes, they did.
And that mall, that building didn't have a loading dock on it.
It had a multi-use platform. I wouldn't have defined it as a loading dock at that time.
So that's the yes to my question. That building didn't have a loading dock.
Yes,
And you needed a loading dock, right?
we did.
So your company had the landlord build a loading dock.
No, we had them remove the guardrail.
Right, you had him remove the safety rail in order to build the loading dock, correct?
Yes, yes.
And that's in the back of the store
It is.
where the emergency exit doors are?
Yes, I don't know if we've defined those as emergency exit doors, but I believe so. If people needed to exit, they could go that way in an emergency.
Well, in fact, those doors are indicated as emergency exit doors, aren't they?
I believe so.
No, there were guardrails outside of those doors.
There were, yes.
Objection, Your Honor. This question has been asked and answered.
Overruled.
There were guardrails outside of those emergency exit doors.
Yes, there were guardrails outside of those emergency exit doors.
And your company didn't prioritize safety then when you had them remove that safety precaution, correct?
When we removed the guardrails, safety was always a concern. We also prioritized at that point in time business efficiency and being able to unload the truck quicker and safer, in our opinion. So in that case, I would say we did prioritize safety to make sure our people didn't have to walk up and down stairs with heavy merchandise.
So to be clear, and as you just said, you prioritized your deliveries over having a safe place to exit in an emergency, correct?
I think we removed the guardrail with the concerns of safety in mind for loading and unloading trucks.
Now, we'll move on. You claim that you don't control this loading dock.
We do not control this loading dock, correct? Yes.
But you do, in fact, use the loading dock.
Absolutely.
In fact, your company uses it exclusively.
We do.
You don't have a specific recollection of any other company using that back area, right?
No.
Any children using that back area?
Definitely not.
Nor anyone besides your employees using the back area?
That's correct.
And your company uses that loading dock close to every day?
I would say even multiple times a day. Yes.
Right. You said that deliveries are made and collected multiple times every day, correct?
Yes. Yeah, I agree with you.
And your company requested that employees clean that back area, right?
Pick up trash, I think is what we said. And yes, if they were going to be in the back area where we got the dumpster, if they saw trash to pick it up. Yes.
And your company sends employees back there to take smoke breaks?
Like I said, the memo was, it's not a requirement that they smoke on the loading dock or even in the back. We offered that as a suggestion, as a place that they could, just to deter smoking in the front of the store.
Well, to be clear, the memo that your management sent said that the only place that they should be taking their smoke breaks on the premises was in that back area by the dumpster, correct?
Correct, absolutely right. But the back area is not just the loading dock. The back area is also where we have a dumpster and a flat, which is shown in the pictures.
Well, you put that dumpster in that back area, right?
Yes, we did.
You put that dumpster directly next to the loading dock.
Yes, we did.
And employees take their trash out there every day?
They do.
Even though you knew that that could be dangerous?
Yes, there is a possibility of danger with the 3-step loading dock, with taking down trash down it.
And you knew that those steps were crumbling because you had seen them before, correct?
Absolutely. We saw that the steps were not in the best condition that they could have been at the time.
And Mr. Gilmore fell down those crumbling stairs that weren't in the best condition, correct?
I believe that's where he fell. It may have been over the loading dock, but yes, that is the area in which he fell.
Mr. Geller, are you saying that you don't even know where your employee fell for the reason that you're here today?
I know that he fell in the back of the store, down the stairs, off the loading dock. I wasn't going to be particular about whether he fell down the stairs or off the side of the loading dock because it has the edge there too.
Well, nonetheless, where he was the place that you designated as the smoking area, correct?
No. We gave it as a suggestion, but there was absolutely no requirement that they smoke on that loading dock.
Now, nonetheless, I don't know if it was a requirement or not, there wasn't a light out in that back area, correct?
There was a light, it just wasn't under our control. Sometimes it was on, sometimes it was off.
Nothing prevented you from getting a switch to control that light, right?
Nothing prevented us from doing that, correct?
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Mr. Geller, since you guys instituted that that smoking break policy in the back in, I believe it was 2015, from that time to the time where Mr. Gilmore fell off the platform or the loading dock, did anyone fall down those stairs?
No.
No further questions, Your Honor.
Any recross?
No, Your Honor.
May the witness be excused, Your Honor.
Witness can be excused.
Your Honor, at this time, the defense would like to read some lines out of Perry Hayden's deposition.
Give me 1 second.
Yes, Your Honor, of course.
You may proceed.
Starting on page 2 of Perry Hayden's deposition, on line 5 through 12. Good afternoon. Could you please state your name for the record?
Good afternoon. My name is Perry Hayden.
How old are you?
I'm 35 years old.
Where do you live?
I live in Austin, Texas.
What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
Moving down to line 22. And what do you do at OSHA as a compliance, safety, and health officer?
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Moving down to line 16. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands. I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
What kind of education did you receive before becoming an inspector for OSHA?
I graduated from high school, and then I went on to Texas State Technical College, where I got an associate's degree in occupational safety compliance technology. Then I went on and got a second associate's degree in environmental technology compliance.
What are those degrees about?
Well, these are really training programs dealing with the hazards of machines, safe work methods, environmental hazards, workplace hazards, and various safety issues. These are literally the degrees you need if you want to do something like work for OSHA. That's why I got them, because I figured working for OSHA would be a good, steady job.
Moving on to page 5, line 6. All right, Mr. Hayden, how are you involved in today's case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Moving down to line 23. During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
How do you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous, and that would necessitate a citation.
Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Moving on to line 24. 3. Mistaken. Okay. Oh no, sorry, Your Honor. Okay, moving to page 8, line 20. There we go. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails are not required on loading docks because they are not feasible. You can't very well load something onto the dock with a bar in your way.
Have you had a chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of the landing in the back area of the store?
I'm sure Miss Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Miss Danes don't deal with loading docks.
Was this area behind the store exclusively used as a loading dock?
No. It is my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well. But I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key here thing is that Chimes used this area as a loading dock. That's what matters.
No further lines at this time, Your Honor.
Anything from the plaintiff?
Yes, Your Honor, just one section. We'll be beginning on page 6, line 11 through 23, continuing on to page 7, lines 1 through 8. Question, did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Why did you inspect that area?
At the beginning of every inspection, I asked the representative for the employer to outline for me all the areas where their employees work. When I asked that question to the manager at Chimes that day, they told me that the employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
When you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Thank you, Your Honor. That concludes our reading of this deposition.
Anything further from the defense?
No, Your Honor.
Anything further from the defense?
No, Your Honor. At this time, the defense rests.
Okay. Plaintiff, you close?
Yes, Your Honor. Could we take a brief 2-minute recess?
You may.
Thank you. And could we get a time check when we come back, possibly, Your Honor?
I'll do the best of my ability to give you one, yes.
Thank you. I appreciate that, Your Honor.
Okay, y'all ready to proceed with closing arguments?
Yes, Your Honor.
Glenn, if you may proceed. Oh, your time check is 36. You've done 36 minutes and 37 seconds. That's
Understood, Your Honor.
pretty- And the defense has done 25 minutes and 48 seconds.
Your Honor, before I begin, may I reserve any time I have left for rebuttal?
Uh, the
I will
answer-
I will not use all of my time, Your Honor. I need about 2 minutes.
I think that then you can reserve 2 minutes for rebuttal.
Thank you, Your Honor. And with that, may I proceed?
You may proceed.
May it please the court. Your Honor, opposing counsel, good afternoon, members of the jury. Safety first. That was the first thing that I told you when I came up here today to talk to you. Safety first. But as we heard today, the defendant company never put safety first. Because for Chimes department store, the only way was the easy way. The only way was to slip on by and let safety fall through the cracks. Jordan Gilmore, in this case, did everything that he could. Jordan Gilmore, in this case, worked for Chimes department store. And Chimes department store owed Jordan a duty to keep him safe. A duty to keep him safe when he was going to areas that he was instructed to go to. A duty that Chimes department store failed to meet. Members of the jury, you now have to decide if the defendant should be held responsible for their negligent conduct or if they should just get away with it. In order to make that decision, you have the testimony of the witnesses. You saw the evidence presented, and you will have the law that will be given to you by Judge Dreyer. And Judge Dreyer will soon tell you that the defendant department store had that duty, had the duty to provide a safe place to work, to provide him with adequate lighting and protections and precautions to ensure Jordan Gilmore's safety. And today we have proven by a greater weight of the evidence, or more likely than not, that the defendant breached that duty and was a proximate cause of Mr. Gilmore's injury. And we have proven that today because the defendant failed to meet minimum guidelines and allowed safety to fall through the cracks. And today we heard from Jordan Gilmore, an active churchgoer that was born and raised right here in Waco. We heard that he worked at Chimes department store for 10 years. And while working there, Mr. Gilmore was a smoker who had to take smoke breaks. And he wanted to make sure that he took them in the right spot. He wanted to make sure that he took them where Chimes department store told him to. So he took them in that back area. And this place was designated by the defendant. It was used by the defendant, and it was improperly maintained by the defendant. We heard today that the defendant's store put aesthetics above safety instead of putting safety first. The aesthetics of the store were more important than the safety of the defendant, or of Jordan Gilmore, when they forced their employees to smoke in that back area. Now, we heard today that this area included a landing area, a set of stairs, and a dumpster. But we saw those stairs. We saw that the stairs had loose and cracked concrete, that the defendant himself admitted was not in the best condition. There was no guardrail surrounding that area or the stairs. And the only light that was available was coming through the open door. Now, the defendant kept saying that They couldn't control the one light that was there, but he admitted that nothing prevented him from getting a switch to control that light. And instead of installing that switch to control that light, he forced his employees to go out there to take out the trash or to take smoke breaks or to receive deliveries in the dark without adequate lighting, without adequate precautions, and without adequate protections. And while the defendant wanted to say that he didn't require them to go out there, it was a suggestion. Members of the jury, we saw that memo. We read that memo. That memo clearly indicated that the only spot that they should be smoking, the only spot that they were allowed to take that smoke break was in the back area. While the defendant wanted to claim that, well, the back area isn't the loading dock, members of the jury, we saw the photos. It was all the same thing. We saw the loading dock next to the dumpster that was placed by the defendant himself. Now, none of these, while he required his employees to go out and use it, he said something interesting that I wrote down because I wanted to make sure that I got it correct. He stated that they forced their employees to go out there even though they knew that there was a possibility of danger. Even though they knew that there was a possibility of danger. Now, none of this excuses the defendant from failing to meet minimum guidelines laid out in the International Building Code and the Occupational Safety and Health Administration, or OSHA, regulations. Today, we heard from a professional engineer through deposition, Kelly Danes, and that her opinion was that the defendant did not meet any of the regulations provided by OSHA or the International Building Code. You see, there was a lack of a guardrail that is required on areas like these. There was a lack of lighting, with the only light available coming from the doors at the top of the stairs, and the light that is up there circled in red. Well, the defendant just said, yeah, we can't control it, even though nothing is preventing me from doing so. And there was a door encroaching on the path of the stairs, directly blocking the path from the bottom of the stairs back into the store. Now, with no railing on this platform, with no light coming through, and with crumbling concrete, there were safety issues that slipped by and fell through the cracks. Employers are required to ensure that employees are safe and are free from recognized hazards. But the evidence here today and the defendant's testimony himself showed that they ignored those hazards and let them fall through the cracks and slip on by. The defendant was aware of these hazards. And we heard from the OSHA officer who inspected the Chimes department store, Perry Hayden, who told us that a representative told us that an employee of Chimes department store told him that employees work in the back area, that they take smoke breaks in the back area, which prompted him to walk on out and see if that area was safe. And he was alarmed at what he saw. He said he was alarmed at the crumbling concrete, at the lack of a guardrail. Because this OSHA inspector knew right away that this was an unsafe condition. But that OSHA inspector let Chimes department store slip on by. Let Chimes department store slip on by just saying, well, they said it was a loading dock, so my job's done here. Members of the jury, the evidence has shown that only one person is to blame for what happened. And that is the company that designated a known dangerous area as their smoking area. It is the company that designated employees to go out there without the proper safety precautions. It is the defendant company that recognized the bad conditions of the steps that they were requiring employees to go up and down numerous times a day. Because while we understand that Mr. Gilmore isn't perfect, he tried to be. And that's what the defense is asking you to do here today. They are asking you to say that we want to live in a world where nobody can make a mistake. Everybody must be perfect. Don't you dare make a wrong step. Because if so, and if you fall, there will be nothing there to protect you. And while they're asking for Mr. Gilmore to be perfect, we're asking them to meet the bare minimum. Just do something to even try to make a safe environment. Members of the jury, you heard it here yourself, that the defendant prioritized deliveries over safety, that the defendant knew that those stairs were in a bad condition, and that the defendant, when making the decision to remove the only safety precaution they had, so that our employees' safety isn't worth losing a loading dock. Members of the jury, you heard all of the evidence. You've heard all the testimony, and you've seen all the evidence. And when you go back to deliberate, we ask that you find the only just verdict. Find the department store, Chimes department store, fully liable for their actions and failures. Thank you.
Defense?
Yes, Your Honor, may I proceed?
You may proceed.
May it please the court. Members of the jury, I want to emphasize that this case is about the plaintiff's choices and how the plaintiff's choices led to the consequences that brought us here today. We're here today because the plaintiff decided to make a choice to slip on by a door that was blocking their path, a door that could be opened all the way. We're here because that plaintiff is trying to slip on by taking responsibility. They're trying to slip on by you. If you fall for this story, then what are we going to do when this local family business, who's been running a business for decades, suffers from this? You heard a lot about Chimes department store today. People's grandparents in Waco have been going there. People's parents have been going there. And now people in Waco still go there because they know they can count on this family-owned business. You heard from Mies Geller, who carries on the legacy now as the owner of Chimes. His grandfather started that business and he looked up to that. He wanted to achieve that too. His father took over, and then Reese made sure to orient his future so that he could be the owner of Chimes. When he graduated from college as a Baylor Bear, he decided that he wanted to start as a buyer and work his way up, show his dedication to this family-owned business. Now, you heard about how this company moved into the current location where the loading dock is in 2005, and it's been there ever since. Now, I want to talk about this loading dock. I want us to look at what this loading dock really is. Let's look at Exhibit 2. Members of the jury, this is that loading dock. We're not looking at a balcony. We're not looking at flights of stairs. We're not talking about 10 to 15 feet drop. Members of the jury, we're talking about a loading dock that's a couple feet off the ground with 5 steps. A loading dock that has been successfully used by employees day after day after day since 2005. Now, I want to move on from this picture. Now that you know what we're really talking about here. That loading dock was made into a loading dock because, as you heard today from Reese Geller, the department store wanted to make sure that their employees had an easy time unloading and loading stuff off trucks. Every single day, employees are tasked with carrying heavy stuff off those trucks. And that's why they removed that railing, members of the jury, because Chimes department store wanted to make sure that if that's going to be used as a loading dock, their employees can use it easily. But they had to ask permission to remove those railings because they leased that property. They're not the owners of it. Or they do not lease that property, but they lease the rest of the building. Chimes was responsible for their own trash. They needed a place for their dumpster. They were in the middle of a strip mall, so they put their dumpster in the back. Members of the jury, these are all regular business practices. Now, I want to take you back to one of the things that I asked you to focus on when the plaintiff took the stand today. The first thing that I asked you to think about and listen for was the familiarity with that loading dock. That plaintiff had been working there for 10 years. That plaintiff, as we pointed out, smoked a pack a day. And so they had to take a smoke break at least once a day, every day back there. Additionally, the plaintiff also took out trash once or twice a day. They estimated they'd been out there about 20 times a week. And 20 times a week for 10 years. That plaintiff went out those doors, down those stairs, back up them, and back inside with no problems. When that smoke break was instituted that got more employees to go back there if they want to take a smoke break, all of those employees too went out those doors, down those stairs, and up those stairs without a problem. The plaintiff was very familiar with this loading dock. And that plaintiff knew that there was no railing on that loading dock for the purpose of loading boxes into trucks and taking them out. Now, before we get to the second thing that I told you to listen for, I want to talk about the jury charge that you're going to be read today. I want to look at the plaintiff's burden that they had today. First, the plaintiff had to show you that the condition it posed an unreasonable risk of harm. Members of the jury, I don't know how many times I have to emphasize how many hundreds and thousands of visits down those stairs, up those stairs, and through those doors happened. Now, opposing counsel kept bringing up these regulations that was against, but I want to point out that, as you heard, Perry Hayden, who actually works for OSHA, came and inspected it, and because it was a loading dock, Perry Hayden said, why would there be railings on a loading dock? He did not cite them for anything. But I want to bring up a couple of those regulations that the plaintiff brought up in today's case. So first, I want to talk about when they talked about the door that blocked the stairway. Let me be clear, members of the jury. You heard today from the plaintiff himself that this is not the door open all the way. The door is pushed back all the way to the wall. This is not the door opened all the way. I also want to talk about how the plaintiff kept bringing up stuff about the stairs. Members of the jury, we're here to determine what was the proximate cause to the injury of the plaintiff, and that plaintiff didn't fall off those stairs. That plaintiff fell off the loading dock. Additionally, the plaintiff brought up how there were no lights, no lights, no lights. Well, as you heard today, the defendant couldn't control that light out there. They weren't leasing that property. That switch was in a completely different building. Now, I want to go back to that jury charge because not only did they have to show that there was an unreasonable risk, which, as I pointed out, they have failed to show, they also had to show that the defendant knew or reasonably should have known of the danger posed, the danger specifically that we are dealing with today, the danger of an employee falling off the loading dock. I'm not going to harp on this too much, members of the jury, but as long as that family owned that business in that building, not a single employee fell off that loading dock until the plaintiff did in 2019. And lastly, I want to talk about the last thing they have to prove, which is that they failed to exercise ordinary care to protect Jordan Gilmore from the danger by both failing to adequately warn Jordan or failing to make that condition reasonably safe. Members of the jury, this comes down truly to the proximate cause, what you think caused Jordan Gilmore to fall. Jordan Gilmore fell off that loading dock, and you cannot expect the defendant to put a railing on the loading dock. Now, I don't want to look at this anymore, please, the jury charge, because I just want to talk to you about that second thing that I asked you to listen for, and that was the choices the plaintiff made, because members of the jury, ultimately, the plaintiff had the burden to prove to you that the defendants in this case were a proximate cause to the injuries that the plaintiff sustained. Members of the jury, let's talk about the events leading up to the plaintiff falling, the injury that we're here today for. Now, the plaintiff was working a 12 to 8 p.m. shift. They knew the sun went down at 6 p.m. They knew it was a winter day in Texas, and yet the plaintiff chose to wait until their last hour of their shift. They couldn't wait a whole nother hour until they left. So they went out there at 7 p.m. in the pitch black, when they knew that that light out there was not under the control of the defendant. The plaintiff knew this. The plaintiff went out there, walked down the steps in the dark without any trouble, took their break, walked back up the steps without any trouble, and then that's when the plaintiff's choices were extremely vital to what brought us here today, members of the jury. The plaintiff's coworker was holding open the door halfway. Now, there were multiple choices the plaintiff could have done. The plaintiff could have simply grabbed that door and pushed it to the wall, members of the jury, because once again, we know that when they went up those stairs ultimately, that door was wide open against the wall. But the plaintiff didn't do that. We know that the plaintiff could have asked their coworker to close that door so they could walk up the platform and they could open it again. But the plaintiff didn't do that either. The plaintiff chose to try to slip by this door when they knew, members of the jury, that there was no railing on that loading dock, because once again, they had been out there thousands and thousands of times. And that is what led to the unfortunate injury that the plaintiff sustained. The plaintiff's choices. The actions of the plaintiffs, the choices of the plaintiff were the proximate cause of the injury that they sustained. Now, we brought an affirmative offense against the plaintiff because, members of the jury, we're here to make sure that if you make choices that ultimately lead to these consequences, that you are held responsible for them. So when you get your jury charge later today, you're going to be asked to answer some questions. Did the negligence of any of those named below proximately cause the occurrence or injury in question? Members of the jury, we're asking you to focus on this one incident. Think about who was negligent and the proximate cause of this one incident. And when you think about that, members of the jury, you know that Chimes department store was not responsible for that incident that night when unfortunately the plaintiff fell off that loading dock. That's what matters in the end. Who was the proximate cause of that one incident? And so because they weren't, you're going to have to write no. And like we discussed before, members of the jury, the plaintiff failed to use reasonable care, and the plaintiff, their choices were the proximate cause of their injury. So you're going to put yes on this. Members of the jury, we're not asking you to make sure that everyone on this planet is perfect. We just need to make sure that the incident we're here for today, the proper person is held responsible for their choices and the consequences that led them here today. That plaintiff tried to slip past that door, and they're trying to slip past you, and they are trying to slip past their responsibility by holding my client responsible for that incident. And you have to make sure that can't happen by finding the plaintiff liable and the defendant not liable.
Rebuttal.
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Ms. Kasemsi came up here and asked you to focus on the plaintiff's choices. The choices that the plaintiff made. Again, she is asking you to find the Jordan Gilmore liable because he made a mistake. And because he didn't fall from a 10 to 15-foot balcony. Members of the jury, do you have to fall from a 10-foot balcony in order for your injuries to matter? In order for your safety to matter? No. She wanted to talk about knowledge, what the plaintiff knew, and the plaintiff's familiarity with the stairs because he went up there 10,000 times. Members of the jury, let's talk about what Chimes department store knew. And what Chimes department store knew, as the defendant himself told you, so that they knew those stairs were crumbling. They knew they could have installed a light switch to control the only light that was out there. And they knew the possibility of danger. But they chose to do nothing about it. And as Ms. Consemsi just told you, you should be held responsible for the choices that you make. Held responsible for the choices that you make. So hold Chimes department store responsible for the choices that they made. Find Chimes department store fully liable. Thank you.
Okay, give us a second, and judges, you now should send your score sheets to Mr. Little. The worst picture taker. Okay, judges, if y'all will come back on after you've done that, and then contestants, I'm going to give them an opportunity to give you some, we're trying to help you for future rounds, give you a little bit of constructive critique that'll help you as you move forward. And I will go ahead and, since I started with Tom last time, I will start with Sarah. If you'll go ahead and give a couple of constructive, and then we'll go Tom, then me. So go ahead.
Great, thank you. So I'll start with Tyler because you are the last one we heard from. And honestly, about one of the most favorite things I heard you say the whole trial was one of the last things you said. And that's usually the order you want to do it in because it's what the jury's going to remember. And the point that you made, you were distinguishing something Jack had said, and what you said was, it's not important. It's more important what the store knew. What did Chime know, as opposed to the victim or the injured party. And so I really liked how you kind of really broke it down just real simply in a way to refocus, because Jack did a good job explaining why the injured person maybe was responsible, or in her opinion was responsible, but you refocused. And that's the benefit of being the plaintiff, or in my career at the government, you get the last word and you get to do that refocus. And I think, man, you went in for the kill on that, and that was fantastic. What I would suggest as a point to work on, a constructive criticism, is I would have liked to have had a little more sympathy with your client. In other words, I thought you did a really good job establishing that, that he's been working with a company for a long time and is from the area and all of that. And then I wrote down something you said in the middle of your direct, and it said, okay, well, we haven't talked about the fall yet. And then you kind of asked something else, and then we kind of got to the fall. And I wanted like more of a dramatic, how did you feel? What was going on? I wanted more smushy feelings about, you got a tough case. And so you got to play on some heartstrings sometimes. And so I would have liked a little more emphasis on the fall, on the feelings, on the hurt. And I understand that this isn't the damages part, but to the extent that you could have done a little bit more with that, I would say that would be my constructive criticism. And but really, Tyler, great job. I really enjoyed watching you. Jack, you made a point that I wanted to hear all day in this fact pattern, which really was the point of the injured party chose to kind of fit around the door. And I think the witness said, well, I'm skinny, I thought I could fit. But I thought that was just a really insightful point that I wanted to hear all day, because, you could just open the door wider or wait or whatever, but, just the choice to try to shimmy through a dock area, which you also did a great job minimizing the size. I liked that. That played well for me, because you're like, look, really, give me a break, right? I mean, it's 3 feet tall. I like that. And as well, how you twisted the removing the rails was safe because it helped with the unloading. And so I thought you did a great job with those facts. What I would say in terms of constructive criticism is that when you were on direct with your client, I thought you also did well humanizing them, and they're from here and this is what they do, and they're really good family person. But I don't think you set Tyler up for a really great cross by saying, well, don't you care about safety? Don't you care about this? Don't you? And I think there's some benefit in getting in front of the bad facts. and not waiting for the defense to walk, blow through them, but you get in front of them and say, geez, your person got hurt. I mean, don't you care about safety? I mean, literally you ask those things so that you can direct, to the extent that it's truthful, the conversation, and not wait for Tyler to blow through it, because she did. And so that would be what I would say in terms of a constructive criticism. And just with the last few seconds, I notice it's people offer evidence differently. And so this is a comment for both of you. And I would like to offer a suggestion of a very short phrase that isn't like I would offer, or I'm moving, or I move to offer, or this. I mean, people offer evidence in 100 different types of ways. And there's a real simple, easy way to do it. Plaintiff offers, plaintiff's exhibit 1. You don't have to say what has been previously marked or previous record, whatever. Plaintiff's offers, plaintiff's exhibit 1. Short, simple. It dispenses with the woods and the moves and the this and that. And it just, again, goes to you having an ownership and control of that courtroom. And if you're saying this is what's happening, I offer this exhibit, period. Stop talking. And so take it or leave it. But I really enjoyed watching both of you in this trial. You did an excellent job. Thank you, Judge.
Tom?
Okay. Again, I agree very much with Sarah that I think you guys have done a tremendous amount of work in a very short period of time to get your heads around the facts. I think that skill to me is more impressive than almost anything else I see in these competitions, is that you've got so many people who are so capable of being quick studies. And I will tell you that being a quick study has a lot of meaning for a lawyer, particularly in this information-laden day. Your ability to look at a set of facts before you go on a presentation, what we'd call a beauty contest to a client, or to prepare for a meeting for a client to make sure that you're hyper-focused on their case in that moment when you're meeting with them. You both demonstrate real skill in connection with that. And that's the first thing that I wanted to compliment you guys on. Let me kind of reverse roles and start with you, Jack, and then I'll talk to you in a moment, Tyler. Jack, I thought you buried your lead in a couple of significant ways. One way is that jurors are typically graphic learners. They want to see a picture. They want to see a diagram. They want to see something of that nature. And you let the plaintiff go about a third to maybe even 40% of the way through the case, showing the stair steps with the door right next to it from an angle that made it look about that wide, instead of showing exhibit number 2, which was admitted from the beginning, which shows this ordinary, tame looking set of stairs that, when you're talking about an unreasonably dangerous condition, you're looking at a set of stairs that look like the back of any mall in America. And so I would say don't bury your lead. Second, along that line, the OSHA testimony is a nuke for the defense in this case. And the reason I say that is because plaintiffs and defendants are expected to square off and fight about this and that and the other. Whenever you have a third party, not hired by anybody, not an expert that's a hired gun who does testimony on both sides, but a government employee whose sole job is to protect the safety and welfare of people. And he comes in 2018 and does an inspection and says, you got a clean bill of health. And then he's going to testify that you deserve that clean bill of health. That's a nuke. That is an absolute nuke in the middle of the plaintiff's case. And I don't remember hearing a mention about it much in the opening argument. So the first thing I would say from a constructive standpoint there is don't bury your lead. And a tiny little argument in that vein that you did start to develop, I think you kind of took a cue or gave a cue to your store owner witness, was it's safer to back up to this loading dock and walk things straight across into the store than to try to come up through a railed process and shoulder heavy things and bulky things up and open the door and that kind of thing. I think that that's something that I would put on the plate right at the beginning. as a defendant in connection with this case, because otherwise what you do is you let the plaintiff, and Tyler did a good job of it, is to say that the balance looks like something versus nothing. I cared, I didn't care. No, we cared, we just happened to care in this particular way. And so I think verbalizing that kind of early and often will improve your situation. Tyler, I thought you were incredibly thorough, but in a way almost too thorough. And it might be that I'm doing nothing but mimicking what Sarah says here. And if so, then maybe that you can sense that that's a point of interest. The place where I would say that it got to an apex was in your examination of your expert witness, where you're talking about this regulation and you're citing it by name, and that regulation and you're citing it by name, and so on and so forth. And what happened is you just kind of get into, and I've done it, kind of a staccato, okay, I know I need to get this evidence into the record. And so by golly, I'm going to get through this evidence as quickly as I can and get it into the record. And it doesn't make any difference whether you get it into the record. You got to get it into the jury's head in a way they care about it. And I'm not sure with a pure piece testimony like that there's all that much I could recommend you do that you didn't do. Perhaps show the regulations, highlight them, draw them out, outline the key parts of them, that kind of thing might enhance that a little bit. But I'm with Sarah. I think the primary thing that you can do as a plaintiff is always going to want to win the sympathy battle. The plaintiff is always going to want to win the hearts and minds. And so things like the fact that his knee was shattered. Now that doesn't come, it's a damages issue truly, but it should come in on liability because it shows how dangerous the stairs are. They look innocent enough, but they weren't, because you can fall with enough force to completely destroy a knee. And that is a piece of liability evidence that you can use. So be thinking as a plaintiff about those kind of cues, I would say. Okay.
Yeah, I thought as the judge in the case, you both did an excellent job. And, I continue to believe that the profession will be well served to the extent that we have people like yourselves coming out to try the lawsuits of the future. And hopefully we can do enough to manage the cost of litigation into the future so that jury trials could still be held in the civil arena. Obviously I'm very concerned about, given my profession that I do right now, I'm the program manager for Bader's litigation management program, LLM program. So I will say that at the outset. My first comment is to both of you, and it has to do with cross-examination because you both did it. And I want to make sure that you don't do this going on into the future. Remember, the principle of cross-examination is keep it simple, stupid. Okay. Cross-examination questions should be about 5 words in length. To the extent the question is longer, then you need to think, can I make it 5 words? That's what I want, because what I want is a simple yes answer to everything that I'm asking, especially at your age. Do not try to draw the conclusion from the witness. You both did it. I think that you did it, Jack, if I recall correctly, you did it when you said this question, and it was you wanted to get back up really quick. You were talking about the smoke break needed to be really quick, and he fought you on it. It could have been disastrous for you. You tried to get him to draw that conclusion that's not in the record, and you don't need to do that. Simply go through the facts. You went down those stairs. Yes. You went up the stairs. Yes. You didn't move the door out of the way. You didn't, you can go through all of those things. You don't have to draw. Then in closing argument, you can make that argument because you can draw a reasonable conclusion from everything you said. But the fact that you went there distracted from the cross-examination. Keep it simple. Don't draw the ultimate conclusion, because I will tell you, a good witness will kill you and destroy it every single time. Tyler, you did it. You did it and you got lucky one time. You got lucky and you used that good luck, but it could have been disastrous for you. Okay. But you said You didn't consider safety when the guardrails were removed. Okay. You're trying to draw the sort of the ultimate conclusion that you want from that witness. And guess what? He hurt you then. Okay. And then you got lucky because you came back to it when he agreed with you. You knew that that could be dangerous. Okay. A good witness is going to kill you and destroy all of the good work that you've done. And the jury is following you. Remember that. The jury's following you, but to the extent that you try to draw the ultimate conclusion on cross-examination, you're going to get hammered. There are very few Perry Mason moments in civil litigation. I tried cases all across the country and I had three of them, but y'all don't even know who Perry Mason is. Okay. Perry Mason used to always show up in trial and he would get the witness to confess during the middle of trial. I was just wrong, or that really was dangerous. Okay. It just doesn't happen. You can say it in closing argument, but don't try to do it on cross-examination. And you both did it. Don't do that. That's my caution. Just stick to the facts that are in your favor in short, simple, easy questions. Jack, I want to ask you a question because I found it to be very interesting and maybe you had a purpose for it, but you kept saying the plaintiff and then you would say they. Every time you said something about the plaintiff, you said they or their. You used that pronoun. Why not use he? Did you do that purposefully?
Truthfully, I did not. I have been practicing those statements with they because I don't know whether the plaintiff, but I need to learn how to obviously switch that for these trials.
I thought it was, I thought it can be distracting. Okay. I don't know today's world, but I mean, this is a he, it's a him. It was his decisions. I like the choices focus that you had, but I wouldn't use that word. I wouldn't use that word they, because I spent my time, and I suspect some jurors in the state of Texas would spend their time trying to figure out why are you using the word they and their when clearly it's a guy, it's a him. I mean, that's just something that I would be conscientious about. Tyler, Jack gave you an open door to bring in the motion in limine, the prior incident. And then she spent the entire closing argument talking about how they'd never had anybody fall off the stairs. All right, didn't she give you, she asked the question. Jack asked the question of one of the witnesses, did you have any incidents where somebody fell off the door since 2005? Well, he said no. I mean, you've got a report of an incident. Okay. That's when you've got a golden opportunity to come back to address that motion in limine. You should have stood up on recross and said, Your Honor, I have a matter that we need to talk about. And guess what I was going to do if you'd have done that? What do you think I was going to do?
You probably would have let me do it. And I guess I wasn't sure.
Yeah, it doesn't matter whether you're sure or not. It's a valuable piece of evidence in light of everything that Jack is doing for you, is it? It's a valuable piece of evidence, particularly what she did in closing argument. I think she said it twice. I think I wrote it down. You said it twice. Guess what? You should have come back on recross. You should have tried to address it. And don't forget that. I did the motion in limine purposefully because that's what some judges do. Why? Because one of the way, I'm going to give you a free piece of advice here. Okay. A free piece of advice. Judges care about one thing. Do you know what it is? They don't want to get, they do not. Everybody, people always say when I ask them that question, they don't want to be reversed. Nope. What they don't want to do is reversed and remanded. They don't want to see you people again because you clogged their docket, right? And you make their stats look bad. It's not just the fact that they get reversed. It's also that they got to try this case again. They got to deal with you again, right? So what lawyers do when you don't bring it back up, you let me off the hook. You completely let me off the hook. Why? Because nobody brought it back up. And I'm never going to be reversed because of my ruling on the motion in limine. Right? So bring it back up, get a ruling excluding the evidence, as opposed to a ruling on the motion in limine. And here you got a pretty good shot because I'm telling you, I would have let it come into evidence. Make sense? After what she did, I would have let it come into evidence.
Yes,
Okay?
that makes sense.
That means, Jack, you got to be careful with how you phrase the questions, and you got to have your witness prepared for what the answer should be. Got it? You both did a fine job, and those are just, look, those are just small things to give some consideration to. And I tell people all the time, when I sit down and I think about my cross-examination, I literally try to keep it to 5 words or less. You do that, and it'll make your life a whole lot happier. Try to see if you can do that going forward. 5 words or less. I'm not saying you can always do it, but 5 words or less, pretty good way to do cross-examination. Okay. All right. Thanks, guys. Y'all. I can't let y'all go. I don't think I've got a. Did y'all turn your stuff in? Hmm. Y'all give me a second. Let me see if I can figure out what.
While we're waiting, Tyler, I wanted to mention to you when I was a baby prosecutor, I was trying a armed robbery that occurred in an HEB. And the 18-year-old came in with a gun and held up the manager. He had worked there previously, so he knew where the money room was. And he had a prior bad act. And it was, I filed my 404B to try to admit it. And the court, it was kept out in a motion in limine. And towards the end of the trial, the defense actually opened the door. And I didn't really realize it until, he was still convicted. It was on video. But I didn't realize it. And it was like that evening that I realized they opened the door and I didn't walk through it. Now there's something to be said for trying conservative prosecutions because you want to preserve your conviction on appeal. You're trying it for the record and a little bit for the jury. But so that happened to me one time, and I promised myself I am never going to miss that door opening. And it is something that has stayed with me in 20 years of prosecution. So I hope you now have experienced that before it really means something to an actual employer. And so you'll always kind of keep in the back of your mind, just be ready for that door to open because it's, if you miss it, you're going to, there's a lot going in trial. So it happens. You will miss things. But I will never miss that again.
That's exactly why Janice Graham Jack had the marshal go get the witness, because another witness opened the door on an issue that had been about alcohol that had been excluded or had been there was an in limine ruling on. And so that's got to pay attention to what people say. It's a good thought. All right, guys, we are done. Good luck in the rest of the competition. Y'all are excellent lawyers. If I was still employed at a law firm, I would have hired you in a heartbeat to come and do whatever you could for me, at any rate, or with me, or teach me something. I guess that's the best way. Teach me how to do things. All right, guys, y'all are done. Tom, Sarah, it was great to see y'all. Thank you for all y'all's work. Good luck to you.
Thank you for your time, everyone. And Jack, great job. Great round.
Thank you, guys.
Thank you.